Item for pronouncement of judgment, item number 38, RSA 185 of 2013.
Second appeal dismissed. Yes,
My lord, I have an urgent matter to be listed.
when,
What happened, lordship,
when,
on next Tuesday, because otherwise appeal will be abated. In the meantime, the respondent, loan respondent died. Matter was listed
okay,
on,
okay.
on
Tuesday.
Tuesday.
For listing matter
When,
on Monday only.
Monday, RSA,
Under
It's
which-
still
in
pending
which
for
column?
15, my lord. It's still pending for 15, 2003,
On which column? Lordship is asking on which column?
on orders.
Yes, my lord, I beg apology, my lord. In respect of item number 21, my lord. My senior is administration, my lord.
21.
After 1 week, my lord.
On the appeal being made by Mr. A.K. Hussain, learned counsel for the appellant, SSL is the matter. After?
1 week, my lord.
After 1 week, okay.
2nd or 4th December, may I pray?
Pardon?
4th December.
Ah.
4th December.
Highlight. My please, your lord. My lord, MSc application, MSc appeal, my lord, the 2016 matter, my lord.
For
Hearing,
Hearing.
my lord.
hearing,
My-
hearing in December not possible. In the first week of January,
2016 matter.
take it that from him.
Early obligation.
Lordship, MSc appeal but the MC of 2013 for coordination of delay. It was last listed on 6 or 2023. It may be listed on 26 or 29.
29th.
Okay.
29th.
May I please, your lordship? With a humble prayer, I beg to mention for listing my lord, one CRP on Monday, my lord, for orders column, my lord. Analogous matter has already posted on my lord.
Okay.
On 27th.
Lordship, analogous matter has already posted on Monday, my lord.
Okay, all right.
Much.
Yes,
May I please, your lordship? Lordship, I beg to mention for listing of one I on Monday, lordship.
in
Lordship,
which
may I-
column?
Motion, lordship.
Motion.
Lordship, on Wednesday, Monday, we have given few
Because
cases.
the connected matter is listed on 20 lordship in the lower court lordship. So it is very obliged, lordship.
Yes,
Please, your lordship, I beg to mention item 14 of today's list. My senior is not well.
who
Kindly,
is your senior?
Didas. Can be fixed next week, any date, lordship.
On the appeal being made by Ms. Tinlong, learned counsel for the appellant, SSL is the matter on.
Any date,
6th December. 6th December.
lordship, yes, lordship.
Please, your lordship, I beg to mention an IA for listing on Monday because the connected RFA case is listed before your lordship court on Monday.
Okay.
A listing of an intest case for coming week on 27th or 28th.
Take it that from him.
27th.
Oblige.
Please, lordship, prayer for listing a RSA, lordship.
When?
First week of December, lordship.
In which
Because
column?
last listing there is, lordship, 9, 12,
In
21.
which column?
Hearing, lordship.
Hearing.
January.
Hearing,
Lordship, it's
December not
possible
possible.
before vacation, anytime. Not before vacation. I am not.
already lot of cases have been fixed before vacation.
Because
It-
lordship, it's last listed
it
on
may
9,
not-
12, 20, 21. lordship.
It,
It's almost 3 years
your
ago,
matter
lordship.
may not reach on that day.
January, first week of January, otherwise matter will not reach. On 7th January.
Then before vacation, the last week, it may be notified as a
Yes,
motion
lordship.
day.
Yes.
In
Lordship,
that case,
January first week if possible. lordship.
pardon?
January first week.
Yes. First week
7th December. Also 7th January.
Meet please, your lordship. I beg to mention item number 28 and 29, my lord. It has been wrongly listed in the orders column, my lord. Item number 29 is not yet admitted, my lord. 28 and 29. It come in the admission column, my lord. So can it be on 29th of this month, my lord? In the admission column. Item number 29 is
Okay,
yet to be admitted.
you inform the other side.
We have taken the concern of the other side. My lord, my learned friend is representing respond number 2.
Yes, Mr. Kaur.
One, I have taken the concern, my lord.
Yes, my lord. It came-
You are in which matter? This 28.
28, 29, connected matter, my lord. 29 has not been admitted yet, my lord. So it should come in the admission stage. Moreover, services also come to, record has also come, my lord.
Okay. That's prayed for by Mr. Lal, learned counsel for the appellant. This is the matter. On
29, my lord, for admission.
possible.
29. Yes, go to it.
Okay,
In the admission column, lord. So
admission column.
I am deeply obliged.
May I please your lordship? Lordship, I beg to mention item number 19. My senior has some personal difficulties. Matter may be listed
Your good name, please.
R Begum,
Ms. R. Begum, learned counsel appearing on behalf of Mr.
YS Mannan.
Y.S. Mannan, learned counsel for the accused. Recessal is the matter. After 1 week.
The one.
Okay.
Please.
Yeah, please, your lordship, I beg to mention one review petition. I beg to mention for listing one review petition on 25th of November,
Not possible.
then my lord 26th.
January, oh no, December first week.
Under which column?
There is a urgency, my lord.
What are they say?
I have
Review petition in connection with?
one RSA was disposed of.
Hmm.
And the one IA has been filed. I am the respondent in the RSA. And the interlocutory application filed by the appellant and stated that the dispute was settled outside of the court. And the amicable settlement to settle the dispute between the parties and some terms and conditions without filing a written document before the court. And the appellant stated that
When it was disposed of?
disposed of in the year, the High Court by order dated 26/6/2020, and in connection with IS Civil 974 of 2020. That 2,50,000.
Who had disposed of the petition? No, disposed of the case. Final order was passed by whom?
As by this Honorable Justice Prashant Kumar Deka
Acha.
in IA, and directed allowed the application filed by the appellant and directed that registry should draw up a compromise decree and that the interlocutory application should form part of the
So
said compromise.
in the first week of December, then
First week of December, other matter are there, my lord, or other
When?
RSA hearing matter are there.
when fixed?
3 December 2, my lord, Monday.
Monday, 2nd December.
Yes.
Okay, on that day.
my lord.
May it please your lordship, I beg to mention one RSA to be listed on the orders column.
When?
May be listed on 28.
28. Possible.
Thursday.
Okay.
May I please, your
Your
lordship?
lordship, I beg to mention for listing lordship, I am at your lordship, immediate lordship.
Next week.
December first week, on 4th December.
With your lordship permission, my lord, I beg to mention my item number 43, my lord. See, this matter may kindly be taken up next week on if your lordship's permit on Wednesday, my lord.
43.
43, my learned friend is here.
And for petition.
Yes, on the pair being made by Mr.
MC
Sami, learned additional PP. Recessal list the matter on
Wednesday,
Wednesday.
next Wednesday, my lord, that will be my
27th.
27.
Okay. Yes,
My lord, a civil revision petition for hearing, my lord. It's a eviction suit, my lord, for hearing any day in the first week of January, my lord.
On,
At the 2019 matter, my lord.
take a date
on
from
9th January.
Please oblige, your lordship.
May it please your lordship, I beg to mention two MFAs not listed in last years. It's a 10-11 years old matter.
Hearing matter.
Yes, yes.
Take it that from him.
No, madam, January, one on seventh, another on ninth.
Lordship, if December, any date. can-
December may not be possible.
January. Otherwise,
Much obliged.
for motion, item number one,
From which place to which place?
From Silchar to Hujai.
On what ground?
Already two matters pending at Hujai, my lord, instituted by me, and he has already entered appearance. I have mentioned in,
So you belong to Hosai.
yes, I am from Hujai,
You got married with the respondent who is residing at
Silchar.
Silsar.
In paragraph 6, page 5, I have given the number, my lord. These two cases are pending in Hujai,
Page 5.
page 5, paragraph 6.
What it says, those proceedings are pending?
One is under DB and appearance stage, he will file. Already he just entered his appearance and supposed to file his written statement.
Heard Mr. Yayuddin, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure read with Article 227 of the Constitution of India. The petitioner has right for transferring FC civil case number 486 of 2024 pending before the Court of Learned Principal Judge Family Court Kasar Silsor, instituted by the opposite party against the petitioner under section 9 of the Hindu Marriage Act 1955 for restitution of conjugal right to the Court of
District Judge.
Judge Hosai or to any other competent court of Hosai district. Mr. Uddin, learned counsel for the petitioner, submits that the petitioner got married with the opposite party and thereafter lived together as husband and wife at Silsor.
Right.
Since when she has been living at Hosai?
36/2024.
When the marriage was solemnized?
31st January 24. After 6 months, yes, she has been driving out. Marriage was
Their marriage was solemnized in the year 2022.
no, 31/1/2024.
2024.
And driven out on
31/1/2024.
36/2024.
And thereafter marital discord surfaced between them, and ultimately she was driven out from the matrimonial home on 30/6/2024, and since then she has been living at her parental abode at Hosai, and that two other proceedings being MR case number 224 of 2024 and DV case number 287 of 2024 pending in the courts at Hosai, wherein the respondent has already entered appearance. And as such, it is contended to transfer the FC case number so and so from the Court of Learned Principal Judge Family Court Silsor to the Court of Learned District Judge Hosai. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. At what is this that FC case is pending?
First notice issued. I am asked to appear on 32 is the notice.
And
26
considering the
11.
submission of Mr. Uddin, learned counsel for the petitioner, and also considering the facts and circumstances in the record, is there any interim there?
Yes.
Further proceeding of FC civil case number 486 of 2024 stands stake till returnable date, list after 4 weeks.
Obliged.
Item number 2.
May I please, your lordship?
Yes.
Lordship, here the issue is, lordship, while preparing the MSc claim application, delay of 45 days have
No,
occurred.
on the other day, I have directed
Yes.
you.
Yes, sir. To apprise this court when the police case was registered.
Mm.
Lordship, it was registered on 1/12/2022. Date of accident was 26/11/2022, and the FIR was registered on 1/12/2022.
One. Accident took place on
26/11/2022.
and the FIR was registered on
1st December 2022. Under section 279/3048 and registered as Gulaghat PS case number 342/2022.
that you have already mentioned in the petition.
Lordship,
You have mentioned the number in the petition.
case number I have not mentioned, but my lord,
Do you have the certificate copy of the order
yes,
of the FIR?
yes, lordship.
You do one thing, you file an additional affidavit, bringing on record that FIR.
Obliged.
Person to order of this court dated 4/11/2024, Mr. M. Dotto, learned counsel for the petitioner. Apprise this court that in connection with the accident that took place on 26/11/2022, one FIR has been lodged on 1/12/2022. And he has already obtained the certificate copy of the aforesaid FIR. Accordingly, it is provided that Mr. Dotto shall file one additional affidavit enclosing the said FIR on or before
16 December. Lordship.
short date.
Short date can be given.
6 December.
I can file it
6 December.
by next week. I can.
Next thing.
29.
Obliged.
29. Item 3.
My lord. I have prepared this revision petition challenging the order dated 3/10/24 passing Miss case 21/24 by the learned additional district judge 1, Kamrup Metro, Guwahati, by condoning delay of 729 days in filing probate case without there being any sufficiency of causes. Hence, this petition about this material irregularities committed by the learned court, because the respondent, she having knowledge and for years together she is sleeping as per her own advertisement statement made in her delay petition annexed here is Annexure 1, page 13 to 20. There are two, my lord, there are two cases pending, one filed by us and another by the beneficiary of the will. And that was, she is waiting, the executor is waiting for the outcome of those cases. And accordingly, after disposal of that, she has come for filing probate case with a condemnation petition of 722 days. But there is not a single word which has prevented her to file within the time. Not to speak any
No, a
cogent
probate
reason.
case, she can file at any point of time when the
Normally, it
necessity
is
arises.
3 years from the date of death of the testator. And from the knowledge also, she can file, but when there is a delay petition, there should be the sufficiency of the causes which has prevented her. But that was not there. I have challenged that
No,
point.
first you have to show since when the period of limitation starts.
Limitation start from the date of death of.
Hmm.
Thereafter, if there is a certain cause of action,
Hmm.
here in her petition also, there is nothing cause of that is she knows she has waiting the outcome of the other cases which I have filed in title two in respect of the land.
Somewhere developer, Mr. Keshu has that.
There is a
When the
lack of-
person concerned died? When the person concerned died?
Oh, yes, two, huh? Oh, 18, 210, 18. 211, sorry, my lord. 211, 2018.
What is the relevant provision in Limitation Act?
Limitation, section 5 only, section 5 and this 137. 137, but that is from the cause of action.
Hmm.
Arose.
Hmm.
But here also, there is no any cause of action, only the date. The date is in 18. She is supposed to file
No,
within 3 years.
when cause of action arose?
On the date of death of the testator.
Hmm.
According to her petition of delay, she is awaiting the outcome of those pending cases where this land involved in the will was there. So that is not the cause of action accrued. Even from the date of knowledge also here.
You come to this Article 137 of the Limitation Act.
Yes, yes. There is no limitation for filing such type of cases
Hmm.
which has not been enumerated in the list.
Therefore, I am asking you, from who is that the limitation is counted here? 726 days, from who is that it was counted?
From the date of death.
Hmm.
From the date of the testator.
So, when a right to sue accrues, that has been dealt with by Supreme Court in one of the case.
Yes, my lord, but here in this
Mhm.
case, there is a right to approve appeared on the date of the testator. Huh?
No. You say one of the Supreme Court judgment, Shakti Bhog put interest is limited versus Central Bank of India and another civil appeal number 2500 of 2020. You go to copy. We list it on Monday. You come prepared with those judgment. List the matter on Monday.
Item 4.
May I please, Your Lordship? My lord, in this case, might improve order dated 12/4/24. Annexure 5 land at civil judge, junior division, Kolkata.
Mm.
And the exercising power under section 10, state the further proceeding
Mm.
of TS case number 30, that means he state the case during showing that another suitors.
You see, in both the schedule B of both the title suit,
But the trial said was a
the parties are same.
No, my lord, parties are not same. Switzerland also not
May
same.
not be, but what section 10
The
of the
allegation is, my lord,
CPC?
in the clear allegation in TS number
Hmm?
38, Your Lordship,
Hmm.
allegation of fraud and forgery of 2 sale deeds. But that sale deed was not challenged in the original PS 222.
Hmm.
That is not there, and these are suppressing facts, so new facts. Our suit is different nature, Your Honor. Section
No,
38.
it is in respect of schedule B in both the title suit.
My lord, parties are not same. And cause of action is quite
No,
different. The cause of action arose regarding allegation of
barring few,
forgery
almost
of 2
almost
sale
the
deeds.
parties are same.
Cause of action, national suit is quite different, my lord.
Hmm.
But main allegation in TS number 38/2008 cannot be decided by that court because in that case, TS number 222 earlier suit filed only for partition of their father's property, but plaintiff in this TS case number 38 challenge the 2 sale deeds is suppressed, not produced, not relied on the same. So cause of action arose on the allegation of fraud and forgery of 2 sale deeds, my lord. This complaint is suppressed, not no cause of action shows regarding this. So, and mutation also obtained by fraudulent means. So we have to file separate suit as per decision also the Honor will file. When AIR 2010, Guwahati 8,
You come to first section 10.
section 10, my lord. Section 10, when subjects matter, parties, issues, cause of actions are different. That section 10 is not applicable in that case because our case is filed on different allegations that is false and false.
No, the relief sought for is same in both the suits.
Recovery portion, my lord. Cancellation of sale deed. But in that earlier format suit,
You come to the pair portion of the first plaint.
recovery portion was section 6.
Page number 39.
Sorry, my lord, I have not wrote the complete brief, my lord.
Then why you were submitting before the court? Cause of actions are different.
Possible for the listed other way. And that clear with the facts, details, facts, my lord.
without going to the record, how can you appear before the court and submit that the cause of actions are different in both the cases?
My lord, my
Are you trying to
main
mislead the court?
allegation-
Are you trying to mislead the court?
No. May please adjourn and fix any other date that I can clear before the honorable court.
On the
They-
prayer being made by Mr. B. Hussain, learned counsel for the petitioner, rests and lays the matter on Wednesday.
27th. Matter number 5.
Yes, ma'am.
Your Lordship, Senior Counsel, Mr. James Sahiwala is on legs. Now, let me kindly take up the matter after some time.
Item 6.
Make with the lordship. The lordship, the petitioners are the plaintiffs, right? If they filed a suit before the learned trial court. Page 17, your lordship, kindly see the plaint. There are 4 plaintiffs, lordship. Page 17. Plaintiff number 1, Kamala Khatun, lordship. Plaintiff number 2, Chan Mia, and plaintiff 3, Tara Mia, and 4, Rohitan Nasa. They all are related, lordship. Plaintiff number 4 is the mother of the 3 plaintiffs, lordship. During pendency of the suit, lordship, the plaintiff number 2 and 4 died. So, lordship, they filed an substitution application that is on page 81, annexure 6. Without any condonation application, lordship. And thereafter, they have corrected that mistake and again filed a condonation application. As there are some mistake errors in those petitions, lordship, they accordingly filed 2 other amendment petitions also, lordship. One is 1046 and one is 855, lordship, 854, lordship. So these 4 petitions were rejected by the learned trial court by order dated 27/8/2024. That is the impugned order, page 97, lordship. All the petitions were received by the other side. They did not file any objection, lordship. But
Maybe merely because they have not filed objection, that
Lordship.
cannot be the ground.
yes, lordship.
So
they
you
have-
show me how the impugned order suffers from any illegality or
99.
arbitrariness.
Page 99, lordship.
Yes.
Relevant portion.
Hmm.
From the petition number 4623 under order 22 rule 3 CPC, it appears that the plaintiff filed the petition stating that the petition number so-and-so was filed within time, but thereafter on 26/4/2024, the plaintiff filed the petition under 5 of Limitation Act by admitting that the petition number 46/2023 was filed after the period of limitation, which are itself contradictory. But lordship, petition 46 says, as there was a suo motu condonation granted by the Supreme Court, lordship, they were under an impression that the petition was within time, lordship. There is a long delay in filing the condonation of delay petition from the date of filing the petition number
But
46.
have you mentioned that aspect in the petition before the trial court?
Yes, lordship.
Show me the petition.
Petition annexure 6, page 81.
Annexure 6.
Yes, lordship. Page 81.
No, page 85.
That is amendment petition, lordship.
Annexure 6.
Annexure 6 contains 2 petitions, lordship, one amendment and one, lordship, order 22 rule 3. Page 81 is the original petition, lordship.
Why 2 petitions are marked as the
Lordship,
annexure
that is
6?
amendment petition of petition 46, lordship. In para 1, I have stated that the suit is fixed today for SR, lordship. Suit is still at the stage of SR, lordship. And after all this, we have mentioned that in para 6, page 83, that the Honorable Supreme Court of India in a case of suo motu extension of limitation. Paragraph 6. Your Lordship, paragraph 7, there was a mention that this period of limitation would be counted from the date of 1/6/22. As such, the present petition is within the time of limitation. For deletion of this paragraph, Lordship, one petition was filed. And for mistake in quoting plaintiff number 1 instead of plaintiff number 4, Lordship, another amendment petition was filed, Lordship. So, Lordship, there were 4 petitions. One is Lordship substitution, one is.
Where is the number of the case of Supreme Court in your petition?
Lordship, that is Somoto 03/2020.
Where you have mentioned it?
That was not mentioned, but
Then?
that is, Lordship, known by everyone that Somoto.
Therefore, you are not supposed to mention it.
Lordship, that was not. Lordship, there are some discrepancy in the petitions. For that, Lordship, plaintiff may not suffer. I am before. If your Lordship may
No,
kindly allow.
the way the petition is drafted shows how much conscious you about the case, about your own case.
Lordship. There are some discrepancy in the petitions, Lordship, that I admit, Lordship. For that, Lordship, may I pray before your Lordship, if your Lordship gives a chance to the petitioners to file appropriate applications, or for these lacunas, technicalities, Lordship, the substitution, the entire suit will evidence because it is a joint suit, Lordship. Prayer was for right title interest and recovery of possession, and they all are related, Lordship. The legal heirs of plaintiff number 2 are not cooperating, so they are not giving the death certificate also, and they are not signing wakalat number to be included as a plaintiff, Lordship. So we mentioned in our petition that they may be added as pro forma defendant by substituting plaintiff number 2. Here, due to technicalities, Lordship, the petitioners may not suffer. For that, Lordship, I have one judgment of 1985.
Not necessary.
Lordship. Only I am praying before your Lordship. Suit is of the year 2016. It was renumbered in the year 2021. And still suit is at the stage of SR or evidence, Lordship. If a chance is given to the petitioners.
Pardon, Ms. R. Chaudhary, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 27/8/2024 passed by the learned Civil Judge Junior Division, North Salmara, Abhaipuri, entitled suit number 20 of 2021. It is to be noted here that while impugned order dated so and so, the learned trial court has dismissed the petition number 46, 2023, 854 of 2024, 853 of 2024, 854 of 2024, and 1046 of 2024. It is to be noted here that by the impugned order dated, it is also to be noted here that by the impugned order dated so and so, the learned trial court has dismissed the petition number 46 of 2023 filed by the petitioner for substitution of the legal representative of the deceased plaintiff number 4 and plaintiff number 2.
They prayed for striking out the name of plaintiff number 4 as because her other plaintiffs are her legal heirs.
And white petition number 1046 of 2024 under Order 6, Rule 7 CPC, tried for amendment of the petition number 46 of 2023 for proper adjudication. And And white petition number 854 of 2024 under Order 6, Rule 17, right for amendment of the petition number 46 of 2023. And white petition number 853 of 2024 under Section 5 of the Limitation Act. The petitioner has applied for condonation of delay for a period covering 1/6/2022 to 3/1/2023. The learned counsel for the petitioner submits that due to some inadvertence mistake on the part of the petitioner, the condemnation, the petition under Section 5 of the Limitation Act could not be filed in time. Under the as the petitioner was under the impression that in view of the decision of the Honorable Supreme Court in Somoto case number 1 of 2020, the period of delay. Your petition is at page number
Page 81. That paragraph 6 is page 83, Lord, 83.
at the period of limitation from 15/3/2020 to 28/2/2023 has to be excluded. On account of COVID-19 pandemic. And the learned trial court has dismissed the said petition for filing substitution petition. It has to be excluded on account of COVID-19 pandemic. Rather than court has dismissed the petition for filing substitution. And that the petitioner may be given another chance to file a petition before the learned trial court by setting aside the impugned order dated 27/8/2024. Having considered the submission of Ms. Chaudhary, learned counsel for the petitioner, and also considering the given facts and circumstances on the record, this court is inclined to dispose of this petition by setting aside the impugned order dated 27/8/2024 and directing the learned trial court to afford another opportunity to the petitioner to file appropriate petition and thereafter to hear the same in accordance with law. In terms of this CRPI will stand disposal.
Number 7.
My lord, this is like a massive petition, my lord. I am seeking some time, my lord, so that I can repay the money, my lord. Even when I applied for my lord sale permission before the my lord, DC, my lord, which was pending, my lord. So can I have a look, my lord? I have page, my lord, 85 and 193, my lord. This is the my lord. I have applied before the DC, my lord, for sale permission. After completion of the sale permission, my lord, I'll pay the
What is your pair in this petition?
for giving some time, my lord. So that matter the sale procedure may be completed, and after that matter I receive the money and I repay the money to him. I'm not contesting matter. I'm not denying that matter. I'm not denying anything matter. Only matter I applied for sale permission matter, which was still pending matter. So due to pendency matter, I have not completed the sale procedure. And the agreement for sale matter I have already two agreement for sale. matter.
You tell me how this petition is maintainable.
This is one type of mercy petition, right?
Mercy petition.
One type of mercy petition. Only for the CRP. matter.
Whether such kind of pair is contemplated in the Article 227 of the Constitution of India.
One my lord, 151 my lord is
151.
151.
151.
151. But sometime maybe given my lord.
Sometime means it is a money decree.
This is a money decree, my lord.
Then-
No, my lord. I am repaying the money, my lord, but my financial condition is very pathetic, my lord. That's why I am trying to sell one of my property. And in this regard, my lord, I have executed two agreement for sale, my lord. And after executing the sale deed, my lord, I have applied for sale permission.
When you have applied for sale permission,
Sale permission on 19/8/2024, my lord, 23.
where is the document to show that you have applied for sale
My
permission?
lord, page 85, my lord. Page 85 and page 93.
The execution case was filed in the year 2021.
2020.
Since then, you could not manage the money.
My lord, I am trying, my lord, I am seriously trying. my lord. I was in class 1 protector.
What happened? What happened about the money appeal number 1 of 2021?
My lord, that was not press money.
Not press means?
My lord, due to my lord COVID-19 and after that, my lord, due to my lord, jurisdictional, my lord, some jurisdiction has changed, my lord. So, my lord, this close, my lord. I am not
Why the-
denying, my lord. I am not denying anything, my lord.
Where is the impugn order?
Page, my lord, 48. My lord, page, my lord, 50.
$53.
53. That could be 52. On the same date, my lord, when my lord, execution case was filed, on the same date, my lord, this, my lord, writ of attachment was issued. My lord.
Is there any bar?
No, my lord.
No.
Well, I have not informed, my lord. I am, my lord, coming to know, my lord, much later, my lord. I am coming to know, my lord, on my lord, 16th, 2020.
This 54 is order dated 16/8/2022.
My lord.
But as per the cost title of your petition, that is not the impugn order.
My lord, cross title, my lord, page 2, my lord. Writ of attachment issued, order dated 28.
No, it is first page you come to.
Process, my lord, that, my lord, I have filed some two petitions, my lord, for state execution proceeding. That was rejected.
Where is that order?
That was, my lord, page 92.
Page 92 is the application for granting permission.
No, not permission.
Page 92.
92.
Page 92 is Annexure 5.
Annexure U, my lord.
92, page 92.
My lord. Order dated 3 days.
Here, Annexure 5, it is application acknowledgement.
90. Annexure V, U, my lord. Annexure V, 93. Annexure 92. My lord. Order dated 3/10/2022.
Okay, Lord Mr. Conacher, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner has challenged the correctness or otherwise of the order dated 5/8/2024 and 3/10/2024 and the order dated 28/9/2021 passed by the learned Civil Judge Senior Division Number 1 Kamrup in money execution case number 13 of 2021. It is to be noted here that by the impugn order dated 28/9/2021, the learned
Civil Judge number 1. Page 50.
what is that order?
53, madam.
'53.
53. Annexure G.
Has issued writ of attachment upon the judgment debtor and by the impugn order dated 5/8/2024, the learned trial court, the executing court has dismissed the petition number 5120 of 2024 filed by the petitioner for adjournment on the ground that he had already applied for sale permission before the Deputy Commissioner Kamrup for sale of a plot of land. To pay the decretal amount and therefore prays for adjournment of the case and by the order dated June order dated 3/10/2024. The learned executing court has again dismissed the petition for adjournment filed by the petitioner. Mr. Khonekar, learned counsel for the petitioner, submits that in fact, he has not been challenging the correctness of the order or correctness of the impugn orders dated 5/8/2024, 3/10/2024, and the order dated 28/9/2021. But he only prays for granting him some time so that he can sell the plot of land. For which he has already applied for permission before the Deputy Commissioner Kamrup and Guwahati. And as soon as permission is received, the decretal amount will be paid. Having heard the submission of learned counsel for the petitioner, I have carefully gone through the impugn orders dated so and so, and also the petition and the grounds mentioned therein. Taking note of all the facts and circumstances, this court is inclined to dispose of this petition by directing the learned trial court. How much time you want?
4 months, madam.
No, only 2 months. To grant
Present when,
so
madam,
much
the
time.
permission is.
No. You may not be able to obtain permission for 2 years, 3 years. That may not be the ground. In about 2 months. In terms of about this shared distance.
Coming item 5,
Diploma. The landlord tenant dispute, my lord. My lord, the petitioner has two shops and one godown in the same market, my lord. My lord, the landlord took the rent up to December 2012 in advance, my lord. But thereafter, my lord, from January 13, my lord, he refused to, and they are depositing. In all the cases, my lord, suits are filed. 2 cases, my lord, already admitted, my lord, civil division 48 of 22 and 78 of 87 of 22. And these are fixed for hearing, my lord. I claim, my lord, that in this matter also same, these 3 matters may be hard together, my lord. Same landlord tenant dispute. They have stated, my lord, that up to 13, my lord, 2012 December, they have taken the rent in the month. That is the only matter.
Heard Mr. G.M. Sayola, learned counsel for the petitioner. This revision petition under section 115, read with section 151 of the Code of Civil Procedure, the petitioner has challenged the correctness or otherwise of the judgment dated 5/8/2024, passed by the learned civil judge, senior division number 1, in title appeal number 19 of 2017, whereby the learned appellate court has dismissed the appeal and thereby affirmed the judgment dated 15/5/2019, passed by the learned Munsif number 4, Kamrup, in titles of number 468 of 2012. Peruse the petition and the documents placed on record, and also peruse the interim judgments dated 5/8/2024, passed by the learned civil judge, senior division number 1, entitled appeal number 17 of 2015, and also the judgment dated 15/5/2019, passed by the learned Munsif number 4, Kamrup, in titles of number 468 of 2012. Admit, let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks along with CRP number.
Well, 48 of 22 and 87.
48 of 2022. And
Malad?
only one CRP.
No, two matters. Malad.
The other matter.
Malad?
One is 48.
And another is 87.
87.
87 of 22.
Interim pair will be considered on next date on appearance of the respondent.
Malad, till then, my lord, school may maintain, my lord, because they may.
We will consider your pair.
Malad?
Let them appear.
Malad, at least, Malad, till then, Malad, at least your losses may, Malad, because in the other 2 cases already stayed there, Malad.
Definitely, we will consider your pair. Let the other side appear.
Yes, my lord, that may be possible. My lord, the only thing I must say, my lord, till then, my lord, 1 month, my lord, they may execute the decree, my lord.
They are ready for hearing.
So this case is in motion stage.
My lord?
This is in motion stage.
Yes.
The others are in hearing stage.
Yes.
So would it be proper to take this matter with those 2 matters?
No, not necessary.
The learned counsel for the petitioner submits that there is a requirement for staying the impugned judgment and order the impugned judgment dated 5/8/2024 as the respondent herein may put the decree in execution, and as such, and in the event of execution of the decree, this revision petition may be infructuous. But considering the submission of Mr. Sayola, learned counsel for the petitioner, and also considering the facts and circumstances on the record, the impugned judgment and decree so and so and so stands is the till returnable date.
Item 8.
Please, Lordship. By this application, Lordship, we have challenged the order dated 8/9/2024, Lordship, whereby the learned trial court has rejected the prayer of the petitioner plaintiff for filing a PW and fixing the case for DW, Lordship. Whatever in this case, Lordship, the petitioner.
How much adjournment you have taken there?
Lordship, by filing petition 1, Lordship, but the whatever, Lordship, the petitioner as plaintiff brought a suit for right title interest and recovery of possession, Lordship, and the defendant appeared and contested the case by filing written statement. When the case was fixed for PW, Lordship, the defendant filed a petition, Lordship, calling for a record from 2 records from different court, Lordship, and Lordship will find that page 35 is the order passed by the trial court, Lordship, and thereafter the court was lying vacant, Lordship, and thereafter case has been fixed for put up from time to time and record and PWs, Lordship. One record of the case has already been received, Lordship, and another has not been received, Lordship.
Okay, heard, Mr.
We have the, Lordship.
Learned counsel for the petitioner. This petition under Article 226 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 11/9/2024 caused by the learned civil judge junior division number 2 Mangaldoi in petition number 571 of 2024 arising out of titles number 77 of 2019.
I am so seeking only one last
And
opportunity.
thereby close the evidence of the plaintiff's witnesses and fix the case for DW. The learned counsel for the petitioner submits that the petitioner could not file the evidence of PW on account of absence of 2 case records. What are the numbers of those 2 cases?
Your Lordship will find at page 35. Is CR case number 46/18 and miscellaneous case number 217/1819 from the office of the circle officer, and another
CR
from
case number 46 of 2018, which was pending before the court of learned JMFC Mangaldoi,
no, it was disposed of along with judgment. It was called for
along
Yes.
with the judgment.
8/11/19, and another case record miscellaneous case numbers 217/1819 from the
And-
office of the circle officer.
Base
Dolgaon
case
Division.
number 217 of 2018-19 from the office of the circle officer Dolgaon. And that thereafter the court was also remained vacant. For which the petitioner would not file the evidence of PW in time, and that he may be granted only one chance to file the evidence of the PW. Well, having heard the submission of learned counsel for the petitioner, I have carefully gone to the petition and the documents placed on record, and also the impugned order dated 11/9/2024. It appears that the learned trial court has learned trial court in the impugned order dated 11/9/2024 has held that the petitioner was granted several opportunities on previous dates. and he had consistently failed to comply with the orders. Having considered the submission of Mr. Halder, learned counsel for the petitioner, and also considering the facts and circumstances on the record, this court is inclined to dispose of this revision petition by setting aside the impugned order dated 11/9/2024 and directing the learned trial court to afford only one opportunity to the petitioner to adduce the evidence of PWC. In terms of this CRP, IO stands disposal of.
Set aside the impugned order. Obliged.
Item number 39.
With his honor, my senior son likes an honorable court. Finally pass over the matter for the rounding.
Items for admission, item number 9.
May it please, my lord. Matter pertains to non-payment of my pension and other pensionary benefits, my lord. Pursuant to the last order passed by this honorable court, my lord, the inquiry report is to be produced by the education department. The finance department indicated the same, my lord. Records are with the education.
Whether the affidavit was filed?
My lord.
Affidavit was filed.
Yes, my lord. My lord would have the affidavit at page 24, man. Affidavit from the education department.
Yes.
Yes, my lord. They have given the affidavit, my lord. Would have page 58 running page, my lord. 58, my lord, running page. In the said affidavit, my lord, there is no whisper about any inquiry. But subsequently, my lord, the thing about the inquiry under HC of the subsidiary rules have come out. In the affidavit which they had filed, there was no mention about it.
Wait, please, Lordship. Lordship, the finance department is also an SA party on the last occasion. My lord, previously, my lord, we had when we had argued this case, my lord, we showcased that the petitioner had overstayed for, my lord, 2 years in that particular thing, and he had given an affidavit. My lord, therefore, a thread by, my lord, hearing will be required in this matter. So I pray, my lord, that the matter may be fixed on the 5th, my lord, of the next month, 5th, that is December.
5th, I will not be available in town.
Then, my lord, 4th, if it is possible, if he is, my lord, free enough.
Maybe listed after 1 week, my lord, I will
A
mention.
date may be given, my lord. At on 4th, my lord, I will, my lord, we will be ready, my lord. Today, my lord, we are handicapped because, my lord, the concerned finance counsel is appearing in a different court when he's on Lex, my lord. So, my lord, on 4th, my lord, if it is fixed, my lord, we will, because a set bay hearing will be required, my lord. In this matter.
Lordship, if I may. Lordship, here the matter relates to pensionary benefits, Lordship, of the petitioner, my lords. That has to be finalized by the administrative department, that is the education department. And lastly, we were asked whether any status report has been furnished to the finance department to consider the case of the petitioner. That status report has still not been furnished to us yet, because of which finance department is handicapped to make a decision, my lords. So some time may be granted to the education department. Finance department is also trying to coordinate, Lordship. Some time may be given so that we can come to a logical conclusion regarding the petitioner's case, Lordship.
Matter may be listed after 1 week, my lord, I pray, because, my lord, I'll not be in station for a few days.
Okay, heard, Mr.
Years of
Learned counsel for the petitioner and Mr. You.
A. Fukan, man. A. Fukan for elementary education.
A. Fukan for elementary education and Mr. Soliha for respondent number 10 and 11.
Lordship, yes, Lordship.
10 and 11. And Mr. Talukdar?
I'm appearing now.
Okay. Oh, 1 to 6. On the pair being made by Mr. Fokon and Mr. Solia, learned counsel for the respondents. Rest shall is the matter after 1 week.
After one, I'll mention that. Fact number 10, deeply obliged, man. Deeply obliged.
Wait, please, Lordship. Lordship, yes. I have filed this statutory appeal, my lord, against an order whereby my interim injunction was rejected, my lord. It is a land grabbing case, my lord, and I had filed an injunction application in the land grabbing case. The interim injunction was allowed. Thereafter, after filing objection, my lord, my injunction was rejected, my lord. Now, I have also filed a separate application for injunction. Lordship may consider that first, Lordship.
But the notice was served.
No, the FAO may be admitted, but then with regard to the IA, I have an interim prior, Lordship, that may be considered now, Lordship. What has happened in this case, Lordship, is that
No, without issuing notice in the
yeah, in that case, an interim injunction was granted. After that objection was filed, in that objection, after considering that objection, the injunction was refused, Lordship. But Lordship may kindly say what is the objection given, Lordship. So I may be allowed to place the facts, or it will be clear, Lordship.
well, one by one. First, let us admit this.
Yes,
appeal.
Lordship.
Heard Mr. Decker, learned counsel for the appellant. This appeal under order 43, rule 1, within bracket small r of the CPC is preferred by the appellants. Challenging the correctness or otherwise of the order dated 19/9/2024 passed by the learned additional session judge. Number 2, Nagaon, in Mijay case number 45 of 2023. In special LG case number 27 of 2023. Is to be noted here that by the impugned order dated so and so, the learned additional session judge number 2, Nagaon, has dismissed the petition filed by the petitioner for grant of temporary injunction. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned order dated
19/9/2024.
dated 19/9/2024. Admit. Notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with ID and also by usual process within a week from today. List the matter after 4 weeks.
Now, Lordship, what has happened in this case, Lordship? The appellant and the respondent, they are the legal heirs of two brothers, Lordship. Now, the two brothers have expired, Samad and Khalid. The appellant are the legal heirs of Khalid, and the respondents are the legal heirs of Samad. Now, Lordship, what has happened in this case? There was admittedly one patta and several dugs were there. In all these dugs, Lordship, after the death, they were divided into two parts. One part is for the successor or predecessors of Samad, and the other for the predecessors of Khalid. Now, what has happened? The respondents, in the course of time, after we have inherited the land, we have purchased some of the land from the original owners, Lordship. Now, after when at the stage of in the year 2023, what has happened? The respondents, that is my cousin brothers, they have started demanding these lands to be theirs, and then they have started taking possession. Now, when we have restricted them, there was a fight between both the parties, and they were successful to take possession of two scheduled lands, and rest of the scheduled lands are in possession of ours, Lordship. Now, Lordship, of where perusal, Lordship of Lordship, may kindly see, Lordship, page number 60, Lordship. Sorry, Lordship, may kindly see page number 66, Lordship. That is my
You
injunction
first show me
application.
the impugn order.
Impugn order, Lordship. Lordship would find the impugn order in page number 91. May I just read it, Lordship?
The operative person.
Operative portion, Lordship. So what I'm coming to it, Lordship, is that in the objection, there is no objection given by the applicant, only merely denying the statement. What is the actual fact they have not stated? My case was that I have purchased some portion of the land and I have inherited some portion of the land. They have disputed both the succession and also the purchase part, Lordship. Now, with regard to Lordship, may kindly see from page number 11 in pair number 94. I just read it, Lordship, and then the opposite person and Lordship would understand. In their objection, the opposite parties, among others,
That paragraph number.
11, Lordship. 11. In their objection, the opposite parties, among others, the original owners of the suit land is one Abdul Khalik and Abdul Salam, and both of them were brothers, and they each equally shared their suit lands. The opposite party have, however, denied that after death of Abdul Khalik, the suit land was inherited by so and so. These are the petitioners, Lordship. They have also denied the share of the petitioners that were inherited from their fathers in the suit land number so and so. They have also denied purchase of land by 6 separate sale deeds mentioned therein. They have also denied allegation against them causing disturbance in the suit land and threatened to dispossess them from the suit land of grabbing the land mentioned in Schedule H and I and other related to allegations in respect of the said land. According to them, they have indicated that the true state of affairs in the written statement filed in the main case and the same may be treated as part of the objection. Now, in this case, they have merely denied it, nothing else. According to them, the opposite parties have been occupying their land in PP Patta number 6, which they have got right over of inheritance. They never dispossessed the petitioners from any portion of the land which they have got right and interest from the successor in interest. According to them, the petitioners have been in possession of their land till today. The petitioners have illegally occupying the share of land of the respondent in PP number 35. According to them, the petitioners have no prima facie case. The balance of convenience is strong in favor of the opposite parties, and granting of injunction would be irreparable loss to the opposite parties. Therefore, they prayed for rejection of the injunction petition. A bare perusal of the written statement filed by the opposite party in the main case reveals that during the lifetime of Abdul Salam and Abdul Khalik, amicably partitioned their land, after which each of them got 14 bihas, 1 kathas and 1 lechas. The respondents have been occupying 9 bihas, 1 kathas, 2 lechas of PP Patta number 6, which they have got right of inheritance from the predecessor in interest of Abdul Salam. It is to be mentioned herein that Schedule H and Schedule I of the petition are covered by Old Patta number 6. According to them, it is the petitioner who have been occupying 5 bihas, 1 kathas, 18 lechas of the land of PP number 6. They have been occupying any portion of the land of the petitioners in PP number 6. Therefore, they have prayed for dismissal of the land grabbing case of the petitioner. Perusal of the injunction petition reveals that through several dags and pattas are indicated therein, and it has also been narrated at length as to how all the land which are in possession of the petitioners came to be their possession. However, the land alleged to be grabbed by the opposite parties concerned only 2 plots of land described in Schedule H and I. It is indicated in the petition that the original owner of the land, Abdul Khalik and Abdul Salam, who were brothers, both the petitioners and respondent claim that they have inherited portion of the land from the predecessor's interest. In paragraph number 3 of the injunction petition, the land mentioned in Schedule H and I are indicated as inherited from the predecessor interest of Abdul Khalik. The exact date of death of Abdul Khalik has not been mentioned in the petition. However, it is clear that he died several years ago, as the petitioners has claimed to have mutated their name in the land records in his place. In support of such mutation, the petitioners have annexed Jamamandis, which relate to the land covered in the aforesaid 2 schedules. It is also indicated in paragraph number 4 of the petition
that by sale deed number so and so in the year 1982, 2 kathas 10 lechas of land covered by dag number 37 of patta number 6 was purchased by late Ramzan Ali, that is the petitioner lordship, father of the petition number 3 and 4. Similarly, by sale deed number 5676 of 82, another plot of land measuring 2 kathas 10 lechas are covered by dag number 37 and PP number 6 is shown to be purchased by the petitioner number 1 and 2 and their brothers late Abdul Samad. However, a plot of land measuring 2 bighas, 4 kathas, 4 lechas covered by the same dag number 37 and PP number 6 are also shown to be inherited in paragraph number 3 of the petition. The combined area of the land purchased by the two sale deeds, which are disputed by the opposite parties as not genuine, is 1 bighas. In other words, that the petitioner could not clearly indicate which portion of land allegedly grabbed, which were inherited, and which portion were purchased. There is no clear indication as to why the land covered by the same dag number and patta number were shown as inherited land as well as purchased. This is one of the reasons that the court has found out. Number 2, I'm coming to the why it is wrong. I'm coming to that, lordship. Can you read further, lordship? The date of the aforesaid two sale deeds is the same. Jawabandis of the injunction petition reveals that the PP number 110 and new dag number 276, which corresponds to the old PP number 6 and dag number 33, which schedule H and in column number 10 of the Jamabandi indicates that as per amicable partition dated 27/7/23, the said new dag and new patta were assigned to Ramzan Ali, Abdul Samad, Abdul Jabbar, and Abdul Mutin. Lordship, I'm reading it, Lordship. In other words, perfect partition of the land mentioned in Schedule H was done only on 27/7/2023, subsequent to the date of alleged land grabbing on 14/5/2023. Similar is the case with regard to the land described in Schedule I. Now, in serial number 1 of column number 10 under remarks of Exhibit 10 Jawabandi, it is indicated that the land covered by tag number 33 of patta number 6 were mutated among others of Muhammad Sheruddin, Muhammad Afzaruddin, who is the father of respondent number 1 to 4 as per order dated 19/10/2013 of the circle officer concerned. If that be so, perfect partition was effected after the date of alleged land grabbing, as aforementioned, in the name of the respondents, which were already mutated in the land records in respect of the land covered by the same dag and same patta as mentioned in Schedule H and I. Now, Lordship may pause for a moment here. I'm just pausing for a moment here. Now, the basic contention of the learned judge below was that there was no perfect partition before the land grabbing, and there was same dag and same pattas. Now, the question before your Lordship is, there has to be same dag and same pattas, Lordship. And with regard to the schedule described, that is a schedule which is drawn by me with respect to one which has been, I have been dispossessed. Now, Lordship may kindly see the erection 1, Lordship, of my petition, Lordship, may kindly see 1, Lordship. I'm coming to that. This has to be, Lordship, because there is same dag and same pattas, two brothers were there. If it is divided equally, obviously I will have the same dag and the opposite party will have the same dag. The question is with regard to the schedule land, the land which has been dispossessed by me, and that I have described in the Schedule H and I. Now, Lordship may kindly see in paragraph page number 29. As Lordship have found it, Lordship, the Jamabandi, Lordship. As per order dated 31/2/81, the name of Ramzan, that is the petitioner, A. Samad, mutated in dag number 34, 31, 42, 402 and 33 in place of Abdul Khalik by way of inheritance. So I have been inherited in the year 1981. My name has been given recorded in the record of rights in the year 1981 itself. Now the learned court below has described this Ungo. This description is absolutely wrong. Lordship, I kindly see paragraph number 3, page number 30, Ungo. Lordship has found it, Lordship. Ungo. As per order dated 7/12/86, land measuring 2 kothas 10 lechas covered by Dag number 37 is hereby mutated in the name of Ramzan along with A Salam by way of sale. By the same order, land measuring 2 kothas 10 lechas of land is hereby mutated in the name of Abdul Salam, Abdul Jabbar, Abdul Moten alongside Abdul Salam by way of sale. So, my lord, the contention which I have placed before the court below, that I have purchased the land from Abdul Saman, appears to be true from this umma. But what the learned court below has done, Lordship may kindly redirect to page number 98. That is the order, Lordship. At serial number umma, again, at column number 10, it is indicated that the land covered by Dag number 33, Patta number 6, were mutated in the name of so and so. So there's absolutely wrong interpretation of what is written in the Jamanbandi, Lordship. Lordship may kindly compare Jamanbandi at page number 30 and what is the operative portion in page number 98. Now, the Dag number is the same, the Patta number is the same. The land will divided between two people. So, obviously, the two parties will have same Dag and same Patta. My case is that I have also purchased some land from that lordship, from the land portion of the opposite party. Now, again, lordship is very, lordship, again, as per the Land Grabbing Act, a circle officer's report has to be called. Now, lordship may kindly see the circle officer's report. It is evident that they have indulged land grabbing. Lordship may kindly see page number 100. That is the report of the circle officer. May I just read the report, lordship? That with regard to the aforesaid subject, I humbly submit. Lordship, found page number 100. Lordship, page number 100. I humbly state that a field verification was conducted by the lot mandal as per your letter. It is revealed that file verification submitted by the lot mandal against the applicant Muhammad Abdul Jabbar filed an land grabbing case of 27 of 2023 against the opposite party Ismail Ali and others for forceful land grabbing. After due inquiry, a report in respect of the land Dag number 34, 37 of Pattern number 6 and the land covered by Dag number 40, 41, 39 of Pattern number 35 situated at Radhati village in Auniati Moza is hereby prepared and stated herein below. The petition filed by the petitioner is partly correct. The land Dag number 34, 37 of Pattern number 6 is recorded in the name of petitioners. It is seen that the opposite parties are under occupation of the land measuring 5 lechas covered by Dag number 35 by dispossessing the petitioner and constructing house. It is seen that the opposite parties are cultivating rice in the land covered by Dag number 37. The land covered by Dag number 40, 41 and 39 of Miadi Patta number 35 of the said revenue village are recorded in the name of the applicant and his family members. There is no land grabbing with regard to the land covered by 40, 41 and 39. Lordship, this is the exact thing which I have stated in my petition. Now, would the learned court below say that there is no prima facie case, especially when the circle officer's report is clear that there is a land grabbing. The opposite parties has denied the sale given by me. The only thing that the court disbelieves my story is that the schedule which is mentioned by me and the schedule under occupation of the opposite parties are the same. Now, lordship, if there is two land where Dag number is the same, it has to be the same. The lordship, that with regard to the portion of land which I have been dispossessed, I have described in schedule H and I, that is a matter of trial. Whether 1 bigha of land was dispossessed, whether 4 kathas was dispossessed, that's a matter of trial, lordship. Now, could the court say that I do not have any prima facie case? Or may kindly see what is the last operative portion what the court has said. Hence, it could not in page number 98. it could not be shown by the petitioners that they have exclusive possession of the disputed land and the respondents had no right and title over the disputed land. Hence, the petitioners could not prove that they have any prima facie case. Can this be the observation of the court after understanding what is the facts of the case? I am not denying that the dag and pattas are different. Dag and patta has to be the same. Now, whether the schedule is matching or not, that's a matter of trial. I humbly pray, Lordship, that because there is apparent land grabbing which has been stated by the circle officer himself, and there is an apparent misreading of the Jamanbandi at page number 30. I may be an interim injunction may be granted in my favor, Lordship.
Okay, we'll see you. Pass the order. Will you resume after 10 minutes?
Yes.
Item number 11.
In this case, I'm appealing for the respondents. My Wakalat was initially filed for the condonation of delay. There was a condonation application filed by them, which was allowed. Pursuant to that, this CRP is listed.
Mr. Senior Advocate, Mr. A.C. Sharma is supposed to argue in this case. He's in court number 13. Pass over for the time.
Item 12.
May please the Lordship, in this matter, the title suit pending before the Civil Judge Junior Division, Charaido Lordship. In that matter, what happened, Your Lordship? During pendency of that title suit, one petition for amendment of counterclaim and WS was filed by the defendant one, Your Lordship. On Lordship, filed on Lordship 16/11/23. On the very day, Your Lordship, they filed this petition. The Honorable trial judge passed the impugned order, Your Lordship, allowing them to amend their counterclaim and WS, Lordship, without affording.
What it says the case was pending then?
Lordship.
At what it says that case was pending?
That is pending for filing the filing for Your Lordship amended petition by the respondent, Your Lordship. It is the position.
I'm conceding to his prayer, Malord. What has happened? We filed an application for amendment, Malord. On day one, it was allowed.
Yes.
Without hearing them. So, Malord, let the matter go back. Let this petition be considered in accordance with law, Malord.
Yes, Lordship.
Because without giving them an opportunity to file an objection, it was allowed in my favor.
Okay.
So we may be allowed to file our
Yes, Malord.
counter, Your Lordship, against their petition.
Lordship will fix a date for appearance in the next week. Parties will appear, then the trial court will proceed in accordance with law, Malord, by giving them an opportunity.
Heard Mr. Dasgupta, learned counsel for the petitioner, and also heard Mr. M. Deka, learned counsel for the respondent. Order dated 16/11/2023, passed by the learned civil judge junior division at Soraidew, Sonari, in title suit number 23 of 2022, is challenged in this petition under Article 227 of the Constitution of India. It is to be noted here that by the impugned order dated so and so, the learned trial court has allowed amendment of written statement from counterclaim of the defendant number 1 in the petition number 493 of 2023 dated 16/11/2023. Mr. Dasgupta, learned counsel for the petitioner, submits that the learned trial court, without affording any opportunity of filing any objection or hearing, allowed the petition for amendment of the written statement and counterclaim. And as such, the impugned order dated 16/11/2023 is illegal and arbitrary, and therefore contended to set it aside, and also to afford the petitioner an opportunity to file objection to the amendment petition filed by the respondent hearing. Mr. Decker, learned counsel for the respondent, fairly submits that the impugned order may be set aside and the matter may be remanded back to the learned trial court with a direction to appear both the parties and to afford the petitioner an opportunity for filing objection in the said petition, and thereafter to pass necessary order in accordance with law. In view of the submission of learned advocates of both the parties, and as agreed upon, this petition is allowed by setting aside the impugned order dated 16/11/2023. The matter is remanded to the learned trial court with a direction to appear before it on suggested date.
After 14 days, after 2 weeks,
15 days or so.
no, records are not here, records are there, so
On 2nd December,
2nd December.
2nd
Monday.
December.
Yes.
And on their appearance, the learned trial court shall afford an opportunity to the petitioner to file objection to the amendment petition filed by the respondent hearing for amending written statement and counterclaim.
Amendment file করেছে order 6 বছর।
Yes.
In terms of this CRPI was disposal.
On number 3 and 4.
TNP. Respondent number TNP.
Obliged lordship.
Item 13. Item 13.
No, please be muted. This city is preferred by the claimant for enhancement of compensation losses. Appeal mechanism.
The delay was condoned here.
Criminal losses.
For Mr. A.R. Agarwala,
I'm
learned
extremely
counsel for the
extremely sorry, madam. In the earlier order, so there is an interim order, madam. There may
interim
be a-
order stands vacant.
Says vacated, but that observation. Obliged.
Interim order passed earlier stands vacant. Or Mr. A.R. Agarwala, learned counsel for the appellant. This appeal under section 173 of the MV Act is directed against the judgment and award dated 11/1/2023 passed by the learned member, Motor Accident Claim Tribunal number 2, in MSC case number 266 of 2018. It is to be noted here that by the impugned judgment and award dated so and so, the learned member, Motor Accident Claim Tribunal number 2, Karnataka and Guwahati, has directed the respondent respondent number 1 to pay a sum of rupees 18,30,844 rupees being the compensation, and further directed that the said amount will carry interest at the rate of rupees 7.5% per annum from the date of filing claim petition till realization. Whereas the memo of appeal and the grounds mentioned therein, admit issue notice to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. Registrar shall call for the record from the learned tribunal, place the matter after 4 weeks.
Item 15. Item 15.
Itu.
That's it. Item number 15. Dismissal of the lordship. This appeal has been dismissed, lordship, and everything has been proved. So I humbly submit this case may be remanded back.
Pardon?
This case may kindly be remanded back, lordship,
Why?
for reducing face evidence over a sector from the parties, lordship, if anything is required.
On what ground?
This is dismissed, actually, the case is proved case, lordship. Everything has been proved. Eyewitness, DW 1 and 2, salary is also proved, lordship. And
Let the other side appear, we will hear them thereafter.
Okay, lordship, no problem.
Heard Mr. A.R. Agarwala, learned counsel for the appellant. This appeal under section 173 of the NDA is directed against the judgment and award dated 13/9/2024, passed by the learned member MSCT number 2, Kamrup M. Guwahati in MSC case number 725 of 2022. It is to be noted here that by impugned judgment and award dated so and so. Judgment and order dated 13/9/2024, the learned member has dismissed the claim petition. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and order dated 13/9/2024, passed in MSC case number 725 of 2022, passed by the learned member MSCT number 2, Kamrup M. Guwahati. Admit, issue notice to the respondent returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. Registrar shall call for the record. This is the matter after 4 weeks.
Item number 16.
It is a lordship. Lordship, this is an analogous case. I have filed 2 cases, lordship, 2 appeals. They need to come together, lordship. I will give the serial number, yet to be numbered. It may come any day to up to 2 days, but these need to be heard together also. Because what will happen, lordship, it's a motorcycle accident. One of them was
So,
a rider.
unless we admit this matter, can we issue such direction that it should be heard with that matter?
Lordship, then both the appeals may come for admission together. It will be better because they are.
First, let us admit this appeal.
Yes, Lordship.
Thereafter, we will pass the order.
Yes, Lordship. Lordship, I am filing this appeal on the ground of fraud. What has happened, Lordship? Even the learned member has agreed that insurance company's evidence, defense evidence is coherent and confirmed to the documents. What happened as per GD entries, which have been confirmed by a police officer who had come to depose DW3. A motorcycle was carrying 2 persons. One was a rider, the other was a pillion rider. They hit a roadside tree and met with an accident. One died, the other is injured. Also. This is the official person, but the claim petition has been filed showing another person, a third person, as a rider. The name of the rider doesn't appear in the GD's FIR nowhere also. So this is we have alleged fraud. We have been examined the police officer and the learned member has also agreed also. Despite that, just because the rider says he was riding that should not have been in an allegation of fraud. It ought not to be decided on the basis of the person whom we have accused to be alleged to be the lordship implanted that. There is no other basis, lordship. On the basis of that only this has been decided. Which is why I am saying also both because one of them is a rider, the other is a pillion rider. It is probably to save the rider because he will not be a third party. Only this third person has been introduced as a pillion. That is my case. Which is why I have said also both the cases may be. Even if this one is admitted, lordship, it may come. I'll tag it next time, lordship.
Lordship, my learned said that no FIR is lodged, but I am having the copy of FIR.
FIR is not by self. I'm talking of
Yeah, the
GD.
name of the writer you also mentioned.
I'm
It's a
talking of
receipt
GD
of the
entry.
FIR.
FIR is a self-serving.
GD is the first information on
GD
this.
entry is.
And we have, they could not
Let
prove
it
the
is
case.
admitted, Lordship, it can
We
be,
have proved our
but,
case by eyewitnesses.
Okay, okay. Heard Mr. R. Goswami, learned counsel for the appellant. Then Mr. A. R. Agorwala, learned counsel for the respondent number. Mr. Agorwala, you are for respondent number?
one.
Respondent number 1. This appeal under section 173 of the MB Act is directed against the judgment and award dated 38/7/2024. Passed by the learned member MSCT number 2, Kamrup M in MSC case number 2079 of 2015. File under section 166 of the MB Act. Is to be noted here that by the impugn judgment and award dated so and so, the learned member MSCT number 2, Kamrup M Guwahati has directed the appellant herein to pay a sum of rupees
Lordship,
8,46,566.56 rupees to the respondent number 1.
yes, yes.
To the respondent number 1. Then further directed that the aforesaid amount will carry interest at the rate of 9% per annum from the date of filing of the evidence, that is 16/9/2019, till the date of realization. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugn judgment and award dated so and so. Admit. Issue notice. However, no formal notice is required. No, whether we have to issue notice to the rest of the respondents
Yes, Lordship.
to entry?
Yes, Lordship. Please record.
Okay.
Because it's a allegation of fraud, so their
However,
involvement will be.
no formal notice is required to be issued to the respondent number 1 since Mr. Agorwala entered appearance on our behalf and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. Notice upon respondent number 2 entry be issued by registered post with AD and also by usual process within a week from today. Registry shall call for the record from the learned member MSCT number 2, Kamrup M Guwahati. List the matter after 4 weeks.
This is a fair person.
This is 50% mechanism.
This is an allegation of Lordship fraud. Lordship. Even if I
Yeah,
deposit, that
even
may
by
not
the-
be released, Lord.
But even
No,
by the
that may
police
not be
also.
released, Lordship. We say, I
OC
would
also,
not,
they could not prove
did
that.
not know, Lordship, who is the
They-
rider. He may not be entitled to any compensation at all, the rider.
50%.
I can deposit, but that may not be released, Lordship.
This is death case lordship. From the
It is a
remote
fraud,
part
it is a
of the
This-
Caribbean lordship.
Heard Mr. R. Goswami, learned counsel for the appellant, and Mr. Agorwala, learned counsel for the respondent number 1. This application under order 41 rule 5 of the Code of Civil Procedure is prepared by the appellant United India Insurance Company Limited for staying operation of the impugn judgment and award dated 38/7/2024, passed by the learned member MSCT number 2, Kamrup M in MSC case number 2079 of 2015. Mr. Goswami, learned counsel for the applicant, submits that the appeal has already been admitted and notice has been issued and the record has already been called for. And as such, the impugn judgment and award may be stayed and the appellant will deposit 50% of the amount before the registry of this court. Within a period of?
24 weeks.
No, 2 weeks,
2 weeks, Lordship. It will be a very short time, Lordship.
3 weeks.
Yes, I'll tell you.
The period is allowed. However, the appellant shall deposit 50% of the awarded amount before the registry of this court within a period of 3 weeks from today.
Item 17.
This appeal has been filed on the ground. Multiplier should be 11, it should be considered 13. His date of birth has been recorded in a driving license, but tribunal has considered the post-mortem report. Secondly, tribunal has awarded, Lordship will find, there is a head-on collision between the one Omni vehicle, which was driven by the deceased himself, and there is collision with a truck. No contributing negligence is considered. Third question is, Lordship, cost of litigation has been awarded 20,000. As per 172 of the Motor Vehicle Act, tribunal can award only 1,000 rupees cost on two grounds. When?
No, there is a judgment of Supreme Court, 25,000
No.
cost of litigation.
Supreme Court has categorically stated there is a reference to this matter that regarding awarding of cost, tribunal, whether tribunal is a civil court or not, that has been referred to the full bench. Secondly, the cost can be awarded as per 172 of the Motor Vehicle Act, only 1,000. May I read 170?
Litigation cost?
Litigation cost, only 1,000.
No, in some other cases, Supreme Court has awarded 25,000.
Supreme Court has power under section 142 not.
No, that power has not been invoked there. I can show you the judgment.
Lordship, I understand. But recently, that judgment has regarding tribunal, whether it is civil court for awarding cost, referred to the full bench.
Full bench is insisting of the matter.
Lordship. No, I'm not that on this. Lordship.
Okay, we'll at the time of hearing, we'll consider this.
Lordship. We'll deposit 50% of the award within 3 weeks.
For Mr. S.K. Goswami, Learned Counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 13/8/2024, passed by the learned member, MSCT number MSCT. Kasar Silsor in MSC case number 508 of 2021. To be noted here that by the impugned judgment and award dated so the learned member MSCT Kasar Silsor has directed the appellant herein to pay a sum of rupees. What was the amount?
Amount is 27,50,000.
27
lakhs 50,000.
27 lakhs 50,000 from the date of filing of the claim petition.
Lordship.
What is the date?
Date award is.
No, there's a date of filing of the claim petition.
Date of the filing of the claim petition. 30/11/2021.
30/11/2021.
Lordship.
2021. Where is the memo of appeal and the grounds mentioned therein, and also the impugned judgment and award dated so and so? Admit, issue notice to the respondent. Returnable in 4 weeks, the be taken by registered post with AD and also by usual process within a week from today. Registry shall call for the record from the learned tribunal. Place the matter after 4 weeks. And this IA, similar order, 50% of the amount. 3 weeks.
Published.
Item 18.
This case only they have filed the affidavit, but this take or not, yesterday.
Yesterday I filed my note, as per your lordship order.
If it is not take, mal, it is taken up next week. Mal.
Not take.
Any date, mal, next week.
In the morning, you could have mentioned the matter.
No.
No, had it been mentioned, we could have called the affidavit from the section.
No, my lord, I was late, my lord.
No. Monday, right? Monday possible. Third, Mr.
R. Islam.
R. Islam, Learned Counsel for the petitioner, and Mr. Talukdar, Learned Standing Counsel for
Counsel,
the
element
respondent, number 1 to 4. Mr. Talukdar submits that he has filed one affidavit yesterday, but the same has not been taken with the record. Accordingly, it is provided that Registry shall use the matter on Monday and take the affidavit with the record.
Item 40.
No problem. They are supposed to file affidavit. I think they have filed a affidavit yesterday, Lordship. I have received copy of the affidavit today itself. Affidavit may not be available in the record.
You want to file a reply?
Okay, let me go through the affidavit. Lordship. The matter come up after a week, Lordship.
Okay,
In the
that's
meantime,
agreed by learned advocates of both the parties. Let's list the matter after a week.
Preparing for respondent six, state of Assam.
Okay. Heard Mr. A. Dekar, learned counsel for the petitioner, and Mr. B. Talukdar for respondent number
Elementary education, my lord.
for elementary education, and Mr. Bhattacharya for respondent number
Respondent six.
6. And you? Respondent number 8.
Mr. Talukdar is 1 to 5 and 7.
List the matter after 1 week. In the meantime, the affidavit filed by respondent number 1 to
1 to 5 and 7.
shall be placed on record.
It is not in your Lord, the matter come up on 2nd of December. Lordship.
Ah,
2nd of December.
2nd of December.
For bail hearing,
Amla Lodge.
item 41.
May I please, your lordship?
41 Lordship, today we are filing objection, Lordship.
Today.
Today, Lordship.
Okay, all right. Let your senior come. We'll take it up at 2 o'clock.
Lordship, the objection is not on record yet.
We'll call it from the section.
Lordship, obliged, lordship.
42. Same.
Same.
Items for hearing under order 41, rule 2 CPC, item number 20.
If I may, my lord, agree for a passover for the time being, my lord. Mr. A. Sattar shall appear at the moment and legs in another court. My lord, matter may be taken up at 2. At 2. Deeply obliged.
Item 22.
This item may kindly be taken up with the supplementary item number 45. So both are arising out of the same judgment and decree where the two defendants and they have filed separate appeals. Lordship may take up the item 22. my lord. The brief is ultimately the same, but that same order may cover both. But in this case, the substantial questions of law I have annexed my lord at 284. Here was the case, my lord, where the plaint was filed by the brothers and other legal heirs of one person my lords, who had handed over the plot of land, both the appellants separately. And my lords, these appellants were in possession, my lords, for more than 20 years. And the factum of their possession, that they were under possession and they are still in possession, was admitted the, lords, the evidence of the plaintiffs. And that's, my lord, I will take your lordship. Lordship may kindly take up the plaint, my lord, that is first of all. It is at page 10, my lords. Yes, Miss Pat.
You first come to the memo of appeal here.
Lord.
It is start from page number 1.
Lord.
So where is your substantial question of law?
Yes, that is at page 84.
Page
84. Last page.
Is it part of the memo of appeal?
Yes. Page 84.
How?
I have annexed it towards the end, but ultimately
You see subsection 3 to section 100.
that is there, my lords, but
Then? Is it your submission that we have to ignore it?
well, that possibly cannot be ignored. But the fact of the matter, my lords, my humble submission
You
remains
file
that the-
amended cost item. amended memo of appeal incorporating the substantial question of law.
Lordship, you kindly take it up the next week. I'll file it by Monday. Because there is an urgency, the execution.
All right. Heard Mr. A. Ganguly, learned counsel for the appellant. Place the matter on when? Suggested date?
Yes, 29th, or Lordship may, if convenient, have it on Tuesday next perhaps.
Next Tuesday. Tuesday is hearing day on Wednesday.
Wednesday.
So as to enable the learned counsel to file amended memo of appeal incorporating the substance suggested substantial question of law in both the matter.
Both the
45.
22 or
45.
item number 44.
None appears for the appellant on call. Recessal leaves the matter after 1 week.
Item number 23, matters for orders.
Maybe the Lordship. During the pregnancy, the Assembly recommended transfer of chain minor. So I have to impute again minor. Some notice was remain unserved minors. Some time may be able to take step against those chains respondents minor.
I appear for the respondent number 9, madam. The respondent number 9 retired around 3 years ago. If Lordship would kindly have the order dated 8/5/2023 in this contempt petition. It's been very, attention has not been paid in this case.
8/5/23. Yes.
Lordship will find that respondent number 7 to 24 were implemented by that order. In the IA they were implemented, and here the fact is reflected that they will be now implemented as parties. Lordship should have order dated 22/5/2023. Service report on everybody was awaited. 23/6/2023, Lordship will find only respondent number 18 appears. And Lordship will find on the next order 4/10/2023, the respondent number 25 is implemented. Pausing here for a moment. Once the respondent number 25 was implemented, necessary to have a notice issued on the respondent number 25. That order has never come thereafter. They have not pressed for a notice on respondent number 25. Firstly,
25 is implemented.
He has been
I
implemented.
order dated
4/10/2023 in the IA. But here it will be reflected that they will be required to file a amended cost title. So amended cost title has come. He has been implemented. Now notices had to go to him. That was never paid for. No notice has been issued to respondent number 25 who currently holds an office. That is the first case. Now Lordship would kindly have a look at office note dated 21/6/2023. The office note. 21/6.
Mm-hmm. 21/6.
2023. Is an office note. Lordship finds
Yes.
respondent number 22 and 23, they refuse notice. Respondent number 18 appeared on the first paragraph that the finance department has appeared on that day. And 17, 19, 20, 21, 24, there is no report, no ID card received back. They have not placed it before this court. Now Lordship will see they are trying to press a contempt petition where they are not even trying to have the notices served. They are not having notices issued. Matter pending from around 2014. Respondent number 9, my lord. They are saying an affidavit filed in this case, that case, there is an affidavit in reply. All these things are coming up. Proper parties are not being implemented. How can the contempt proceed? This is the way a matter is to be pursued in the court. A contempt petition.
Key occasions, my lord, we have filed a implemented petition, my lord. Each of every after 1.5 years, keep on changing, my lord. So for refuse my lord, that is amount to accept, my lord.
Should have been pointed out to the court.
should have been
No,
pointed out. They do not
no,
even look into the file. It is just a
No
contempt
way
petition.
connected to the
Pressure.
merits, my lord. No way connected to the merits, my lord. So
Not
far,
how
my
a
lord,
contempt petition is.
Lordship has passed on 10/4/10/23, my lord. May I read the order, my lord? The opposite party opposite party number 20 actually.
Order dated?
4/10/23, my lord. The read the opposite party 25 saying, I am going to commission a secretary to the Gupta Masam, this was so and so.
No, in the writ petition,
My lord.
order dated 4/10/2023.
So contempt petitions actually.
Contempt, my lord. This is a contempt petition, therefore I am saying, they are trying to drop, ask the honorable court to drop contempt proceedings on certain persons because an order has been allegedly disobeyed. This is the way they are tackling a matter. Notices are, they have not paid for a notice, issuance of notice. When notices are refused, they do not come up before this honorable court to say that these persons are committing contempt. They are not taking any steps to see whether the notices are served or not on the other respondents. Just continuing a matter from 2014, it is pending before this honorable court.
No, my lord. No, my lord. That is not the case, my lord. This is the
Orders are reflecting.
All has refused, my refused to accept which may accept this, my lord. So, but Nayan Goa is concerned, my lord. The opposite party say Nayan Goa, the commissioner secretary of the Gupta Basam is aided as the respondent number 25 in the contempt case number so and so. However, the name of the respondent was 17, Sri Vijaya Chaudhary, the commissioner secretary so and so, be struck off from the area of the opposite party number 522. The applicant is amended the perspective of the madam. We have taken this key occasion.
They have not paid for a notice to be issued.
Every after 1.5 years,
No,
keep on changing.
Mr. Ahmed, you please do one thing. You please go through the orders and also through the note sheet. Then you list the name of the contemnors, and against them you indicate which contemnor has received notice and refused to receive notice.
And where notice
And
has been
against to whom the notice has to be issued. You indicate in a separate paper. You go through the record. Accordingly, I will pass the order.
Then we can perhaps proceed in.
Yes.
I appear for respondent number 9.
9, okay.
Sometime whoever left I will again have done.
No, you do the work today. We will pass the order today.
Timing item 11 for admission.
Well, this is a revision application against the order passed by the courts below against me, against the petitioner, declaring the suit for eviction. What happened is this, my lord, the original suit was filed by one Ramnistry and others against the defendant, present petitioner Ramnaran. The case is like this, my lord. The Munshi Mistry was the owner of some plot of land. And Munshi Mistry is the father of the plaintiff. He is the some plot of land. And he let up to some person and there was an agreement with the father of the defendant to sell a particular plot of land under the land of the Munshi Mistry. Accordingly, I am in possession of the land. And there was an agreement for sale of the land. Ultimately, the Munshi Mistry died and the sale could not be completed. Thereafter, his heirs filed a suit for rejectment against the defendant, stating that we are the tenant and we are defaulter in payment of rent. This is the case of the plaintiff and the defendant. So far, our claim is concerned, we have stated in paragraph number
Paragraph number 10 of the WS, page 29. The Munshi Mistry was the elder cousin brother of the defendant, and he has permitted the defendant to use and occupy the land. And later on, he has transferred the land in the name of the defendant. Munshi Mistry has sold the land to the pata number so and so of Dhekazuli town, Fort Park, Moza, so and so. He has Dhekazuli Sonitpur on the consideration of rupees 85,000. Only, and they promised to execute a registered sale deed in favor of the defendant, but expired on 10/8/1995, and so he could not execute the registered sale deed in favor of the defendant. The defendant is a permissive possession, and the consideration amount to Munshi Mistry and had allowed the defendant to occupy his immovable properties.
You were reading page number?
Page number 29.
29.
Paragraph number 10.
Paragraph. So this is in admission stage. We admitted.
Yes.
Yes, Ganguly, you are for respondent.
Yes, sir. I'm for the.
Oh, all the respondent.
I'm for 1 and 2, the others are pro forma. I'm for the contesting respondents.
Others are not contesting respondent.
No, I'm not for them. I'm only for 1 and 2.
No, whether they're necessary party in this appeal or not.
But that is for really for them to follow.
They are not the necessary party.
In fact, the dispute is between us and them. That is the settlement. And there is another part to the execution has already been set in motion. The entire
Please track
purpose-
of their name then.
Yes, but the name of defendant, respondent number, pro forma respondent 3, 4, and 5 may be struck.
They are okay. Heard Mr. S. Sharma, learned senior counsel, assisted by Mr.
B. Halder.
B. Elder, learned counsel for the petitioner, and Mr. Ganguly for respondent number 1 and 2. This revision petition is directed against the judgment and award, no, judgment and decree, judgment and order passed by learned district judge Sonitpur in title appeal number 2 of 2021, dated 3/8/2023. And district judge has upheld the
Finding of the trial court.
Acha, by which the learned district judge Sonitpur has upheld the judgment and order
Decree.
dated 24/2/2021, passed by the learned Munsip number 1, which will make it civil judge junior division number 1 Sonitpur in title suit number 82 of 2015. Where is the memo of appeal and the grounds mentioned therein? And also peruse the impugned judgment and order dated 3/8/2023, passed in title appeal number 02 of 2021, and the judgment and order dated 24/2/2021, passed in title suit number 82 of 2015. Admit. Issue notice to the respondent. However, no formal notice is required to be issued to the respondent number 1 and 2 since Mr. Ganguly entered appearance and received notice. However, extra requisite copy of the petition be furnished to them. Mr. A.C. Sharma, learned senior counsel for the petitioner, submits that respondent number 3, 4, and 5 are pro forma respondents, and they are not necessary party, and their name may be struck off from the array of this petition. Accordingly, it is provided that the name of respondent number 3, 4, and 5 be struck off from the array of this petition at the cost and risks of the petitioners. Recess will call for the record from the learned courts below. List the matter after 4 weeks.
No, date will be fixed. They are in long possession of the premises.
Yes, that may be
without
fixed.
any-
That may be fixed after receipt of the record.
Hmm.
And another fair, they have already started exhibition case.
Hmm.
The execution case number 7 of 2021.
Hmm.
It is mentioned in page 14.
Hmm.
That proceeding may be stayed till disposal of this petition.
That is why I have made the prayer for a date, my lord, because the proceeding, my lord,
No,
date, my lord, this is admitted.
it may be heard very expeditiously. I have no objection. But after receipt of the record from the
Yes,
judge,
of course. Yes, my humble submission is that my lordship will kindly observe that this matter may be heard on expeditiously, my lord, after the records are received. That is the limited.
And
No, there are many important matters. Second appeals are pending since long back. This is CRP.
Look, this matter is without absolutely any merit, my lord. Lordship will find from a perusal of both there is a well-considered, well-reasoned judgments, my lord. There is nothing in the case of the revision petitioner. It is only because section 115 provides a remedy, my lords, in law that people come up and they get the. This is the precisely these sort of orders are to be avoided. My lord, that is.
till disposal of the case, page 14, my lord.
The date will be fixed and one observation
Page
kindly
14,
from your lordship.
pending
That is all.
disposal of this petition.
Okay.
Titling
Mr. S.C. Sharma, learned senior counsel for the petitioner, submits that there is a requirement for staying the impugned judgments and orders since the respondents herein have already initiated a title execution case number 7 of 2021 till disposal of the revision petition. But having considered the submission of learned advocates of both sides, and also considering the given facts and circumstances on the record, the impugned judgment and awards dated so and so, passed by the learned district judge stands state.
district judge affirmed by the
District judge and
no.
also the judgment and order dated so and so, passed by the learned Monsif. Dashboard, sonnet for stands state. Till disposal of the appeal.
till disposal of the
Revision petition.
Yes, till disposal of the revision petition.
Can a date be fixed? Let it be in January end, my lord, no different, but date may come up.
the exhibition case number may be mentioned.
Yes.
It is mentioned.
7.
7 years.
No,
Immediately-
if we stay the title execution proceeding, then where is the necessity of staying the impugned judgments and orders?
Yes. In fact, the proceedings of the title execution case are required to be stayed.
For 17, 12 in the 18.
We will stay the proceeding of title execution case.
Yes.
That is the prayer also.
Delete the other. List the matter on suggested date.
28th January, 20th January.
On that day, an effort will be made to finally hear and dispose of the petition.
I'm grateful.
Item 24.
Yes.
Item 24, Lordship, in this case, we are directed to take steps on the last occasion. But there is no such reflection in the office note, Lordship. Only the office note says that LCR has been received.
No, have you taken steps?
We have taken the step.
I have verified the main case, that is appeal number 721, Lordship. There is no any such order regarding issue of notice. And in the ILO sheet 3826, an order has been passed, that is 20 March 2023. Whereby Lordship a notice was issued, that is reflecting the main case. LCR has already been received.
And I think so, Mohammed Putri appeared.
In fact, Lordship, the case is ready, otherwise ready for hearing, Lordship. We are praying for early disposal because, Lordship, there is no, Lordship, order regarding 50% of the amount. Claimant has, Lordship, incurred huge expenditure, Lordship.
20 years appeared, Lordship.
So they are basically on quantum, Lordship. So, Lordship, I'm praying for a date for final disposal, Lordship, on any day. There is no order regarding 50%, Lordship. Claimant incurred, Lordship, more than 30 lakhs for medical treatment. Subsequently, he died. Award was, Lordship, 70 lakhs. Not a single patient has been, Lordship, released. There is no order to the effect of 50%.
No, it appears that the appeal has not yet been admitted.
Yes, Lordship. That is the order
When?
reflect regarding notice on 20 March 2023 in IA number 3826.
Appeal is admitted.
When?
No. It is not yet admitted. I have seen. I have verified all these records, Lordship. Your Lordship may admit it and post it for hearing, Lordship.
Yeah.
3826 IA 2022.
IA is for condonation of delay.
No, condonation of delay, that was, Lordship.
IA is for what purpose?
Well, that was for amendment
additional
of the Lordship petition.
Pardon?
Amendment of the MSC appeal.
Whether that was allowed?
No, that has already been observed that that will be taken care at the time of hearing. So some order has been passed on 20 March 2023, whereby notice was issued. That is reflected regarding the Lordship, the main case, MSC appeal.
22 months.
No, this appeal has to be admitted.
Yes,
It has
Lordship,
not
your
been
Lordship
admitted.
may admit it as the record has already
Or
come.
Mr. Your good name?
SP Sharma, Lordship.
SP Sharma, learned counsel for the appellant, and Mr. Khan, learned counsel for the respondent number.
Well, at 1, Roman 1, 2, 3, and 4.
Roman 1, 2, Roman 1, 1.
1, 1,
Roman
1.
2, Roman 3, and Roman 4. And for rest of the respondent? Respondent number 2. And your good name, please? Learned counsel for the respondent number 2. This appeal under Section 173 of the MB Act is directed against the judgment and award dated 23rd/7/2021 passed by the learned member MSCT Bongaigaon in MSC case number 65 of 2019. It is to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed the appellant National Insurance Company Limited to pay a sum of rupees 70,05,480 rupees. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and award dated 23rd/7/2021. Admit. Issue notice to the respondents. However, no formal notice is required to be issued since respondent number 1A, 1, 2, no, Roman 1, Roman 2, Roman 1A. 1A or Roman? It is Roman 1.
Roman 1, 2,
Roman 1, within bracket 2, Roman 1, 3, Roman 1, 4. And respondent number 2 entered appearance and received notice. However, extra requisite copy of the petition be furnished to them during the course of the day. And this respondent number 3.
Respondent number 3, Lordship, will be required, Lordship, because one of the ground is we are taking is away planted vehicle issue, Lordship.
owner has already entered. Owner has already entered. Owner of the vehicle.
Who is owner of the vehicle? And this
Yes, sir.
respondent number 2. And driver?
Nobody is equal.
Nobody. Then notice will go.
This will go, Lordship.
Issue notice to the respondent number 3 by registered post with AD and also by usual process with any week from today.
LCR already received.
Place the matter after 4 weeks.
Well, at one IA, they have filed lawsuit for regarding stay of the proceedings.
Lordship, I would have not, not placed in law.
That can be lawsuit then dispose of on lawsuit as they are not present.
Heard Mr. Sharma, learned counsel for the applicant, and Mr. Khan.
2954. 2954.
Learned counsel for the respondent number so and so. And Madam for respondent number 2. This interlocutory application is preferred by the applicant for staying the judgment and award dated 23rd/7/2021 passed by the learned member MSCT OMO in MSC case number 65 of 2017. The learned counsel for the applicant submits that he is not interested to pursue this application. Accordingly, this application stands dismissed for non-prosecution.
One submission lawsuit, as the appellate lawsuit admitted, that may be lawsuit subject to some payment lawsuit. Because the petition, claimant lawsuit incurred huge expenditure.
50% of the amount.
Lordship, that prayer may be taken up in the presence of my senior lordship, Ms. R.D. Majumdar.
No.
Because Lordship, there is a planted vehicle issue also, Lordship.
There is?
Planted vehicle issue, Lordship. Lordship, may use the ground number, Lordship, A.
Maybe at the time of hearing, we'll consider it. You deposit.
Lordship, withdrawal may not be allowed, Lordship. Withdrawal may not be allowed.
We have expended lawsuit more than 30 lakhs rupees lawsuit on medical purpose. Subsequently, he expired.
Okay, withdrawal we will consider later on. First, deposit the amount.
My lord.
The appeal jot admit to kotha kolo tata likhibo. Appeal is admitted subject to depositing of 50% of the awarded amount before the registry of this court.
Maybe.
Diary to the Yes.
I apologize, my lord, when the matter is being called for, could not appear. My lordship is finding challenging an order dated 4/5/2024. The land giving matter to close our right to file our written representation. At page 51. Before that, my lord, lordship may kindly have a look at the order dated.
No, yesterday you have submitted that you have been covered from addiction defense.
Two orders we have challenged, my lord. One is closure my written state representation and my right of cross-examination. Both we challenge. The first time, draw the attention of this honorable court to 4/5.
Page number?
Page number 51. Before that, my lord have kindly look at order dated 3/4 at page 48. Wherein we have filed an application directing them to file the documents. Lordship is got. Order dated 3/4. So let the copy be furnished to the applicant. Next date 10/4/2024, furnished document and written statement. Now that document was not furnished. And it has been reflected in the impugn order of 4/5 itself, my lord. Lordship, may kindly have a look at the impugn order at page 51. Both sides represented, seen petition number filed by the applicants under Rule 10 of such and such, stated that the respondent have failed to file their written statement within 14 days from the date of receipt of the notice. Though this court extended the date fixing today, and as such the respondent may be debarred from filing written statement and case may be proceeded to the next stage as per law. that is framing of point of determination or a framing charge, let the copy be furnished to the other side. And in fact, my lord, as per the instruction, the copy was furnished on 2nd of May, that is 2 days prior to 4/5. And as per rule 10 of the land grabbing rules, my lord, that the 14 days time to be given. Before 14 days, my right of representation that has been closed. Therefore, this order is without jurisdiction. That is my
You
humble.
are referring to rule?
Rule 10 of the Land Grabbing Act. Rules. Section 10 says CPC will follow, and Rule 10 says 14 days time. Assam Land Grabbing Prohibition Rules 2013.
This rule is not here.
We have a copy, my lord. Give a second copy. The respondent or interested party may, and if so directed by the special tribunal, shall file written representation before the special within a period of 14 days from the date of receipt of notice or such extended time as the special may grant. So on appearance, we have filed an application that the document be furnished to us. That was allowed. And that was furnished as per instruction on 2nd May only. Because on the last day of the order, prior to 4/5, there is indicated, my lord, that the copy to be furnished.
No, where is the document to show that you have received the copy on 2nd of May?
Now that we have not received anything, but the last order, lordship will find, prior to 4/5, they furnished the copy without acknowledging the same. That is, but the last order, if your lordship find that there is a order by the court again, last order prior to 4/5, lordship will find at page 49. This type copy, the original copy is also. That is order dated 25th of April. Applicant are present through their advocates, respondent such and such out of station, let the copy be furnished to the other side. And the fact remains, my lord, that on 2nd May 2024, the copy was furnished.
No,
This is one
unless
of
you
the-
will show the date on which you have received the copy, how can we come to a conclusion?
In the update, my lord, in the update, I am stated in paragraph 8 of my application before this honorable court on affidavit. Paragraph 8, lordship kindly have a look. Because there is no acknowledgement on my side of receiving the
No,
copy.
is it not required to acknowledge the same?
Yes, therefore, if I am saying that no documents is received by me, that also cannot be brushed aside. But to the fair enough, my lord, so far the instruction is concerned, on 2nd May we have received the notice. Update. Because on the update, they did not take any acknowledgement from other side. In paragraph 8, lordship have a kindly look that on affidavit I make a statement. Paragraph 8? No, 6. 6, my lord, I'm sorry. Page 11. That applicant's respondent herein had furnished a readable copy of the documents to the counsel for the petitioners herein on an off date, that is on 2nd May 2024, and therefore the written statement could not is missing, my lord, could not be prepared before 4/5/2024. Because the entire order sheet we have produced before this honorable court, which also does not indicate that which date the copy has been received. If we take up the date of 25th of April, my lord, then also 14 days is not completed on 4/5. And this is a land grabbing case, my lord, is a serious consequence to be followed. The civil liability and the criminal, as lordship is aware. And by the second impugn order, my right of cross-examination also to be closed.
Where is the second order?
Second order, my lord, on 510. Before that, lordship may also peruse the order dated 3/9/24, when my right of cross-examination was closed due to the absence of the counsel of the respondents. Thereafter, we filed an application under section 151, my lord, for recall the order and giving us an opportunity to cross-examine. That was rejected by the impugn order dated 510. Lordship may kindly have a look at order dated 3/9 first at page 57. For non-appearance of the counsel, the cross-examination was dispensed with. And fixing 18(9). On 18(9), we have a file an application before the court, the counsel consent, and saying the ground cause, why he did not appear on the day due to the ailment of the counsel. Lordship, kindly have a look at my petition as page 62. There's an application filed on the next day, and Lordship will find in paragraph 9, the counsel has stated
Page number? Page number?
Paragraph 9, my lord.
Page number.
Page 62, the petition starts at page 63, paragraph 9. And this application has been rejected by the impugn order dated 510.
Whether any documentary proof was
No, the council has not produced. The
Then-
council has not produced.
Then-
That is there, my lord. I cannot, because I cannot procure any document. That is there. That is
No,
there.
you are challenging the order of the trial court. You have to justify it.
The lordship is correct. But my
You
only
have to show
submission, my
that
lord,
illegality is committed
Yes.
and there is
No,
arbitrariness
my-
in the order.
yeah, my lord has kindly appreciate that the section 151, my lord is aware, I need not to explain. The court having a power, because court has to assess the
No,
situation.
there,
It is not
there
an
must be
ardent.
some reason for exercising that jurisdiction.
No, the court, I am not filing, court has also asked for that you have to file a document, you not submit or furnish the document, that is there, my lord. That is, I'm only saying, my lord, if the written statement I'm allowed to file, then everything will be in order. That, my lord, kindly, all are the tea garden levelers, my lord. The respondent is so tea garden leveler. And for the fault of the
Maybe law
council
is
also. No,
equally
that,
applicable.
no,
to all
I'm
the-
agree with
all the
this.
citizens.
I'm not, I'm just saying, my lord, I'm just saying for the consideration of this honorable court. I'm not saying this is a legal ground. And lordship is also appreciate that for the default of the council,
No, that is always argued before the court that
Yes, yes.
for the council,
I do
parties
agree, my
should not
lord.
suffer.
But my lord, if I have a right to file my written representation, because it indicated prima facie that order is bad, my lord. What I understood, my lord, I leave it to this honorable court. But prima facie it indicate that the 4-5 order is illegal. So if it is set aside, if it is later on after the notice, my lord, then everything will be in the order. Then if I am filed representation, everything will be covered. That my only humble submission, because here some of the owners, my lord, they have filed, they have no legal, they are not the owners of the land. They are the permissive occupant of the land, and they have filed a case, lordship before against the owner. So all private disputes. So therefore, my respectful submission, my lord, that at this stage,
So
it
we'll
should be
examine and pass the order.
your lordship.
For bail hearing timing matter, I don't know,
Grateful,
41.
Lordship, similar matter has been fixed after a week, Lordship. So these two matter may be listed with along with.
They filed their objection.
Why? Similar matter may be fixed after a year also. So do we adjourn this matter? Is it an argument?
Lordship, they filed the objection, Lordship had called for the record, this will come on record, Lordship.
You ask your senior to remain present in the court. After some time.
Lordship. 42 also.
Same.
Standing item 20.
No, please, Your Lordship. My lord, as per the last date's order, my lord, the respondent side is to present certain documents before the Lordship. And I may also be given the opportunity to go through those documents. My lord. Let me look at that. Let me look at that. After the copy of the board. Yeah.
According to last order, I have applied for the thing. But the thing is that, my lord, it is a matter, it is a appeal against concurrent finding of fact. Concurrent finding of it. Otherwise also, second appeal, it will be on substantial question of law.
Definitely.
But this concurrent finding of law, they have lost two courts. So I think at this stage, it may not be required to go into the evidence issue. Facts may not be required. So law points, whether there is any substantial question of law, that has to be decided. Whether there is any substantial.
Yes,
My
he
lord,
will begin first.
Yes,
Let him start.
That's my lord,
My lord, I shall have to go through because today he has given my lord 2 days, late to.
My lord, it's not have decided. He is in the first trial court, in his first appellate court also, he is having all the evidence with him. These are for the court only. He has all the evidence with him.
My memory is not that sharp that I.
The memory is not, it is not question of memory. It is whether he is having the evidence with him. He is having evidence. His trial court, first appellate court also.
So you want adjournment?
After 2 days, my lord.
After 2 days?
Yes, my lord.
Okay. On the affair being made by Mr. A. Satra, learned counsel for the.
It will be on 27 because.
27, I may not be able, 27, no. 27, I may not be able to do.
December 1st week on second.
It will be on
25th of this month, my lord.
25th.
25th of this month.
Tuesday.
It's 25.
25 is the goal.
25
Sorry, my lord. The calendar which is fixed here is of the year 2025. Sorry. Let me see the 2025.
It is 24.
My lord, 25th is Monday. Let it be on
27th of 27th.
27th.
Wednesday.
Let it be on Wednesday.
27th.
27th.
Wednesday.
Yes, my lord.
27. Okay,
Yes, my lord.
27.
Item number 25.
May please your lordship.
Well, in this FAO matter, an application has been filed for vacating the ex parte order of injunction. This has.
I number 564.
Yes, my lord. 567. Now, my lord, brief facts are like this, my lord. The plaintiff appellant, they filed a suit for declaration.
No,
and
this
injunction.
I is 564.
Yes, my lord. I'm sorry, 564. Suit was filed for declaration and injunction against the, my lord, a club. And the trial court was pleased to issue notice and did not pass any order of injunction on the first date. Only one notice was issued. Against that order, my lord, the FAO has been filed. In the FAO, my lord, filed under order 43 rule 1R. On the first day, my lord,
and the injunction was granted. And my lord, the application was also disposed of on the same date. My lord, granting an ex parte order of injunction against us. Then, my lord, the appellant themselves filed an application for review saying that there has to be a returnable date and notice has to be issued. Then, my lord, that was reviewed and notice was issued. Now, we have received the notice and thereafter, my lord, we have filed our objection in the FAO as also, my lord, in the application for injunction. This is filed, my lord, 564 is filed under order 39 rule 4, my lord, for vacating the ex parte order of injunction. My lord, in fact, this has not been listed for more than 1.5 years. I do not know, my lord, for what reason. With this difficulty, my lord, we have brought it. My prayer is very simple, my lord. Notice was issued to us. We have, by the trial court, before the trial court, we have filed our written statement as well as objection. Now, my lord, before that period, my lord, they came here and they have filed this application for injunction and injunction has been granted. My prayer before your lordship will be, without, my lord, going into the merits of the case, that your lordship may say that, my lord, the injunction matter will be decided by the trial court and till that time your lordship may protect them. The status quo should be maintained, may be maintained till then, and your lordship will direct the, my lord, trial court to decide the injunction. We have already filed our objection, written objection, and also, my lord, in the suit, we have filed our written statement. So, my lord, if I go to, my lord, the facts of the case, facts is like this, my lord. There was a complaint against the plaintiff that, my lord, he wanted to contest in the election of the club, and where the requirement was that he has to be at least a graduate. And he submitted some forged document showing that he is a graduate. Actually, he is not. Thereafter, my lord, notice was issued to him. And, my lord, he also apologized that the matter closed thus. Thereafter, returning officer made a complaint because of his misbehavior. Then, my lord, the matter was decided to be discussed in the, my lord, executive committee meeting and the higher authorities meeting. At that stage, my lord, the plaintiff filed the suit. And, my lord, filed the application for injunction so that no coercive action is taken against him. So, my lord, that in that injunction petition, my lord, the notice was issued. Against that order, my lord, they have come, and, my lord, here an injunction has been granted that no coercive action should be taken. But on merits, my lord,
Where is that order?
The order of the, my lord,
Order of this court?
of the trial court, my lord.
Trial court or this court?
This court, my lord, the injunction order, that is, my lord, dated
23/9/2022.
In IA number?
In IA number 2961 of 2022.
Thereafter, in this review petition, this has been reviewed.
Yes, my lord, reviewed, then, my lord, last sentence was deleted because, my lord, the matter was disposed of on the first day itself. So, my lord, that injunction petition. Then, my lord, we have also filed the review application. That part was, my lord, deleted, and, my lord, notice was issued to us, and we appeared.
Now, what is your prayer?
My prayer is that, my lord, your lordship will dispose of the first appeal itself, my lord.
Remanding the matter to the trial court?
Trial court, and till that time, my
To
lord.
hear the matter and to dispose of in accordance with law.
Yes, my lord, we may time.
Until then, your interest has to be protected.
That of course has to be protected. That will protect him now.
Well, till disposal of the suit, my lord, if your lordship disposes this appeal with a direction, my lord, to continue with the status quo order passed by this honorable court, because my entire suit relates to the expulsion of my membership from the India Club. My lord, if it is, my lord, left to be decided by the learned trial court, my lord, again, my lord, it is at the stage of issues now. The issues will be framed, my lord, after evidence, the trial will be concluded. Till the conclusion of the trial, if for the interest of justice, if the status quo order continues, till, my lord, the decision comes in the trial court, my lord, it will give justice to both the parties.
Till disposal of the?
Till disposal of the title suit. Because it's a matter pertains to only expulsion of my membership from the India Club. I challenge in the suit, my basic challenge in the suit is that there is a gross violation of Article 10 of the Constitution of the India Club.
because by of an extraordinary general meeting, I cannot be expelled. There is a particular procedure to be followed by the India Club as per the constitution, which was not followed. And my basic challenge in the trial suit, in the trial court is violation of Article 10 of the Constitution of India. The first day when the injunction was, basically notice was issued. So on a apprehension that I would be expelled, I approached this honorable court. This honorable court passed an order that no coercive action to be taken. But it was disposed of on the same day. That's why we filed a review petition. The review petition, the respondent appeared. So it is no longer a ex parte order. In the review petition, the respondent appeared, his submission was recorded, and this order was reviewed to the extent that it is not disposed of. A notice was issued and date was fixed.
My lord, if I correctly understand the submission of my learned friend, my lord, the injunction has to be made absolute without hearing the, my lord, injunction petition. In that event, your lordship will take up my order 39 rule 4 petition, my lord.
Well, I have not received.
I have given this, my lord, option because, my lord, so that he is also not prejudiced. The matter of injunction has to be heard, my lord, whether it is allowed by the trial court or not, my lord, or your lordship will hear, my lord. I have my lord, issue with that. But the, my lord, base course should be, my lord, since we have filed their objection, written objection in the injunction application there, my lord, after receiving notice. It is the trial court which should decide. Now, my lord, he cannot make the interim order absolute without, my lord, hearing the injunction petition.
But
that is the submission he is making, my lord.
That's where the appeal is filed before this honorable court, and the petition was heard. Petition was heard in.
We will direct status quo till disposal of the petition by the learned. No, not the title suit. Till disposal of the injunction petition pending
The
there.
purpose of filing appeal will be become infructuous in that event, because my lord, the status quo order which has been granted by this honorable court and subsequently reviewed by this honorable court was in the presence of both the parties.
My lord, the injunction matter has not been heard, my lord,
the
your lordship will see the order.
Well, if I may correct, my lord, this injunction review petition order dated, if I may take your lordship to the review petition order in the file. 20/2/2023.
The injunction matter has not been heard.
Well, this is a review petition. This is a review petition filed under order 47 Rule 1, Code of Civil Procedure Code 1908, with regards to the order dated so and so passed by so and so. Paragraph 3. A brief background of the petitioner case is that the petitioner had initially filed a title suit. Your lordship has got the order.
Got it.
Registered as title suit number 569 of 2022 for declaration of the opposite parties club to convene an extraordinary general meeting to decide disciplinary matter against the petitioner as contrary to the provision of the club's constitution, along with which an application under order so and so was CPC was filed and registered as Midje case number so and so for an order of temporary injunction restraining the parties to take any adverse decision against the petitioner before the civil judge too. However, the civil judge too, instead of granting the order of temporary injunction, and on 21/9/2022 fixed the matter on 20/10/2022 for service report and objection. Thereafter, considering the urgency of the matter, since the matter was scheduled to be held on 25/9/2022, the petitioner had approached this court against the order dated 21/9/2022, which was registered as FAO 51/2022. The petitioner had also filed a petition under order 47 Rule 1 and 2 of the CPC, which was registered as IA number so and so, praying for an order of injunction to restrain the opposite parties from taking any coercive action, including expulsion from membership of the India Club, where the parties are members. The matter was then listed before this court on 23/9/2022, and this court, while issuing notice to the opposite party respondent in FAO number so and so, had disposed the interlocutory application number so and so by granting ad interim temporary injunction in favor of the petitioner. By restraining the opposite parties from taking any coercive action, including expulsion of membership of the petitioner from the Indian Club till the next returnable date. Mr. So-and-so, counsel for the petitioner, submits that the order dated so-and-so needs to be reviewed for clarification and modification. For this court had restrained the opposite parties from taking any coercive action against the petitioner till the next returnable date. However, no further date was fixed, and this court had disposed of the interlocutory application. This has created confusion, and the said order dated 21/9/2022 needs to be reviewed and clarified, modified accordingly. Mr. So-and-so, learned counsel for the opposite parties, also submits that this court's order dated so-and-so is an ex parte order which was passed and disposed without giving opportunity of being heard to be opposite parties and needs to be reviewed. He further submits that the provisions of Order 47 Rule 3 of the CPC has to be followed since the ad interim order was passed ex parte. Having heard the submission made by the counsel for both the parties on so-and-so perusal of the order 21/9/2022 in IA Civil 2691/2022, this court finds that there is an apparent error in the order wherein while passing the ad interim temporary injunction order restraining the opposite parties from taking any coercive action, including expulsion of the membership of the petitioner from the India Club, the words till the next determinable date was added. However, the interlocutory application was disposed of without fixing the date and without issuing notice to the opposite parties. Accordingly, the order dated 21/9/2022 is modified and clarified by deleting the words interlocutory application instead and disposed of. Accordingly, the last paragraph of the order shall read as follows. Issue notice upon the opposite parties through registered post AD, wherein the petitioner is to take necessary steps as per provision of so-and-so. After that, they appeared, and the learned senior counsel is appearing on behalf of the respondent for hearing of the interlocutory application, which was not made absolute. So we have approached this honorable court being agreed by the order passed by this learned civil judge. And if it's relegated back to the civil judge to be decided by the learned civil judge, again, if any adverse order comes, then my lord, there would be a multiplicity of proceeding. Just to avoid that, I am suggesting for an order of status quo to be continued till disposal of the title suit. This will give a justice, my lord, to both the parties. Because the pertinent question is whether I should be expelled or not. Whether there is a observance of article.
That injunction petition is pending before the trial court now.
Not pending.
It is pending.
Not pending.
It is pending.
My lord, your worship has read the my lord review order. Has the injunction matter been discussed in the review order? The only thing that has been done is that since the my lord injunction application was disposed of ex parte on the first day itself, that my lord last part that it has been disposed of, that has been my lord deleted, and notice has been issued. Now the injunction matter is before your lordship and also my lord before the trial court, and because of this interim order, my lord, he is enjoying it without hearing the my lord injunction application.
Well, that's
So,
why
my lord, my submission was that either your lordship will hear my application under order 39 rule 4, or my lord relegate the parties to the trial court. There, my lord, we have filed the my lord the written statement and objection. Now, how can I make a prayer that you make the interim injunction absolute without hearing it? Where the injunction application has been heard, man. First day, my lord, this court passes an order, ex parte order of injunction, and my lord disposes of the injunction application. Then they file the my lord review application saying that the last line should be deleted. That has been deleted. Then we have approached my lord.
Okay. Mr. Biswas, are you sure that the injunction petition has been disposed of in the trial court?
It has not.
But on the first day, the injunction petition was no order was passed, and notice was issued. That's why we filed an appeal. The submission of
No, that application is still pending there. That has to be disposed of.
Yes.
But that disposed of by this honorable court with a direction to the learned civil judge, my lord, till disposal of the my lord, title suit status quo should be maintained. And the submission on the part of the learned Senate Council is that, my lord, they were not heard.
No, that kind of order can be passed only after hearing in the petition pending before this court.
But your lordship will hear now, this order 39 rule 4 petition has been filed by the respondent side for vacating of the order. If your lordship feels that there is a sufficient ground to vacate the order passed by this honorable court, the lordship will vacate it. Otherwise, my petition will be allowed, making it absolute. Well, this is a normal course. Whenever injunction is denied, refused, or not granted, or no order is passed, every person have to apply before the higher forum. That's why we have approached before this honorable court, and your lordship is in session of the matter, so your lordship may hear the entire matter of the injunction and decide either way. And so far is the vacating.
Yes, let us hear your petition.
Your lordship will take up the my lord IA 564. Now your lordship will find, my lord.
One problem, my lord, I have not received the copy of the vacating petition filed by the respondents.
Which petition?
Well, the vacating petition filed by the respondents.
This IA?
Yes.
My lord, I would like to check the records, my lord. How can it be filed without serving a copy on them, my lord? I'll check the records, my lord. But your lordship may kindly see the records, my lord.
I have been informed that my clerk has received today.
How can he receive it 1.5 years back, my lord? And the case is not listed in spite of, my lord, so many requests made to the court. This is how it is, this matter is proceeding, my lord. 17th of January 2023, it has been received by me. This is not the way of delaying a proceeding, my lord.
I'm not
An
delaying.
injunction
I have
is-
been informed one more case is pending. One of the copies received by my clerk. That's what, my lord, my lord, I have nothing to hide here. But if I receive, I have to say, my lord, just now this copy is not. But there is no tactic to delay, my lord. There is all, my lord, these allegations are not correct. But I am here making fair submission to dispose. I am in favor of disposal of the case.
Are you then?
My lord, I thought it will be easier for both the parties, my lord, if the matter is remanded back for there protecting him, that, my lord, he is not agreeing, so I'll argue this, my lord. That would have been the base course, my lord. The
No,
trial court-
yes.
trial
That
court, my
would
lord,
have been
issued-
the best course.
My lord,
That would have been the best
yes,
course.
my lord.
But he is not agreeable, then
It's not
what
that, my
option
lord, the
they-
lawyers have to agree to what your lordship decides.
Hmm.
Lawyers do not have to agree, my lord. We can make only submissions before your lordship will
Definitely,
decide.
definitely.
Well, it will lead to a multiplicity of
What
proceedings.
multiplicity?
If my
What
status,
multiplicity, my
if
lord?
my injunction period is not allowed by the learned civil judge, again I have to approach this
Then you
honorable
have-
court.
How do you know that it will
But
be
this-
allowed here?
Well, this will be a multiplicity of proceeding. But the learned senior counsel may understand the effect of multiplicity of proceeding, filing one after another petitions. But this will cause the decline also. For the ends of justice, I am just praying before this honorable court. I am not pressurizing anyone. I am just praying, my humble submission. But the learned counsel, my lord, senior counsel may understand the implicacy, my lord, and the burden of the client filing petitions one after another.
No, my lord, that means he is apprehensive that his injunction application will be rejected.
Yes, my lord, I am always
He
apprehensive.
is apprehensive.
The clients are always
Because
apprehensive.
he knows, my lord, he doesn't have a case.
Well,
That's why he is apprehensive.
But sometimes in a good case also orders may not be passed, my lord. But these are the apprehension of the clients. Out of this apprehension, we approach this honorable court. Even in like bail matters also, my lord, out of apprehension we come.
Your lordship will taking him, or your lordship will be sending back to the court.
No, he has not agreed to it.
That's not the whether the client counsel has to agree, my lord. to
I am
partial-
agreeing if status quo order be continued till disposal of the suit, just to avoid the
No, that
multiplicity.
can be passed only after hearing the matter, entire matter. We are not hearing the entire matter now.
Your lordship may hear it under order 39 rule 4, the petition they have filed, vacating petition. Your lordship may hear it.
Yes, my lord. Then I continue with the, my lord.
So usually, Mr. Biswas, status quo order till final order is passed by the trial court.
Yes, yes. I don't
No,
have-
no. Final order means final order in the
Injunction.
IA. Interlocutory application pending there.
With all fairness, I made this submission, my lord. I wanted him to be protected till the matter is decided. That also I have submitted.
I am also agreeing to that, my lord. My apprehension is that if, my lord, my injunction petition is not considered, again we have to move this honorable court by another petition. That is my apprehension. If my apprehension is protected by this
But
honorable
then
court,
your
my lord,
lordship will see, it is, he has not come against an order rejecting his application for injunction. The court did not reject his petition. Court said that.
Only
issue
issued notice.
Court has
But
not, my lord,
there
given
is
any
one
finding
judgment
of-
of this court
My lord.
where it is stated that this denial of pair amounts to rejection.
My lord, if your lordship sees that order, only notice has been issued, nothing has been said, my lord, on the injunction application.
No, it means that his interim pair is declined. There is judgment of this court.
Yes, my lord.
That's why.
But then nothing has been discussed about the prayer for injunction also there. Nothing has been discussed. Your lordship may see that order, my lord, that your lordship will find in the FAO. Nothing has been discussed about the merits of the case. If your lordship takes up the FAO, my lord, your lordship will find the order.
Page number?
FAO 51 of 2022.
Page number? That impugn order?
The order impugned is at, my lord, page 91.
Dated 21/9.
Dated 21/9/2022. Instant Mizzi case arises out of petition number such and such filed by the plaintiff under order 39 rules 1 and 2 with section 151. Heard learned counsel for the petitioner at length, peruse the materials available in the case record. On careful perusal of the materials available in the case record, it reveals that the hearing of the OP is necessary before passing effective order. Therefore, issue notice.
Mm.
He has not discussed anything about the merits of the case.
Mm.
It's not a rejection as such. Of course, my lord, that not granting is also a refusal to grant an injunction. But then, my lord, nothing has been discussed about that. He doesn't have any case. Okay, that has not been said, my lord.
Well, this is a case where the learned court did not, my lord, exercise the jurisdiction vested on the court. That's why, my lord, this.
No, that is a discretionary jurisdiction.
Discretionary,
Court
my lord.
may grant it, may not grant it.
Yes, my lord. Otherwise, my lord, I am agree by
You
not
cannot
granting
claim
also.
it as a matter of right. That
Well, it's
I
a
have filed an
discretionary power.
injunction
That's why.
petition,
Discretionary
it has
power,
to be
absolutely.
granted.
And this honorable court, after perusing the records, my lord, the grievance, it feels that, my lord, I am entitled to a grant of injunction, then your lordship may allow my prayer till disposal of the suit. My lord, it will have a, my lord, it will render justice to both the sides. But
Yes, Mr. Sharma, start it.
Now, your lordship has already seen the order that has
Yes,
been passed by
I
the
have seen
trial
it.
court. And my lord, this honorable court also, my lord, on the first day injunction has been granted without even, my lord, recording the reasons. Without recording the reasons, my lord, that has been, my lord, passed. Now, what happened, my lord? The prayer, your lordship will see the prayer in the plain. Your lordship may kindly come to the FAO because, my lord, some cases of papers of that, my lord, plain has to be, my lord, taken into what is his case. Here, your lordship will find in the, my lord, FAO at page 26. The plaintiff therefore prays for a decree for a declaration that the decision of the club committee of the defendant club in its meeting held on 6/9/2022, deciding to convey an extraordinary general meeting of the defendant club to decide disciplinary matter against the plaintiff and acting upon the letter dated 5/8/2022 of the defendant number 3 is null and void, contrary to the provisions of the constitution of the defendant club, and as such inoperative and cannot be acted upon. My lord, action has not been taken. Only, my lord, the meeting was convened to discuss. At that stage, he has come, my lord. It's not that, my lord, he was, my lord, any action has been taken against him. I'll refer to that, my lord, particular document. Then B, for declaration that the decision of the club committee of the defendant club taken on 5/8/2022 to seek reply from the plaintiff, acting upon the letter dated 5/8/2022 of Dr. Ashwin Chaudhary as the returning officer is illegal and inoperative and void. What happened, my lord? The facts are like this, my lord, is there in the plea and in our objection also. My lord, and a notice was issued for my lord, election. The plaintiff, he also filed his nomination for the post of joint secretary. And my lord, according to the constitution, one has to be a graduate. So he submitted a photocopy of a document showing that he is a BCom. Then, my lord, the returning officer asked him that he produce the original. Because, my lord, these are all club members, everybody knows, my lord, who is a graduate, who is not a graduate. Then, my lord, he came to the office. And, my lord, in the absence of the secretary and, my lord, other higher staff from the clerk, my lord, he has taken out his nomination papers, tore it, and misbehaved. And therefore, my lord, the returning officer filed a complaint. In fact, my lord, returning officer had written to the Guwahati University to confirm, my lord, whether he is a graduate or not. And the documents will show, my lord, 4 documents have been placed to show that, my lord, he is a graduate. That is the crux of the matter. So, my lord, so far as, my lord, he was suspended initially, then he filed an appeal. From 6 months, it was suspension was for a period of 6 months. On appeal, my lord, it was reduced to 2 months. Then, my lord, he filed a review application. Then, my lord, they considered and reduced it to 1 month. That chapter is closed. But, my lord, this matter relates to the complaint lodged by the returning officer of the misbehavior and the, my lord, the furnishing of false document to show that he is a graduate. So, this is, my lord, what the prayer B is about. Then C is for declaration that the action of the defendant number 3 lodging a complaint on 5/8/2022 as the returning officer and also to communicate with the purported authority of Guwahati University outside the club are unauthorized. So, my lord, he wanted to confirm, since the, my lord, the plaintiff did not produce his original document to show that he is a graduate, the return, and my lord, the returning officer was misbehaved, then my lord, he wrote to the Guwahati University and he could confirm that he is not a graduate. So my lord, he says that writing that letter is also unauthorized. That is one of the prayer. Then my lord, prayer D, declaring notice that is 79/2022 of the extraordinary meeting of the General Council to be held on 25/9/2022 as illegal. So my lord, it was proposed that in the extraordinary general meeting, this is one of the agenda that whether a disciplinary action should be taken against him or not, that will be discussed. At that stage he came, so that my lord, the meeting is not held. So my lord, he wants, the plaintiff wants that my lord, there should not be any consideration regarding any disciplinary action against him. No action has been taken as such. Before my lord, the meeting was held to discuss whether to take any action or not. Then my lord, the suit was filed. So these are his basic my lord, primary prayers. Then my lord, E, that is his ground, legal ground, for declaration that the decision of the executive committee to convene an extraordinary general meeting of the defendant club to enable authorize the general council to take a drastic step of expulsion of the plaintiff from the membership of the club is in violation of Rule 10 of the Constitution of the club and illegal and not permissible. Therefore, my lord, your lordship has to read the clause 10 of the my lord Constitution of the club. These are his primary prayers. Now, coming back to the my lord IA, your lordship will find page 6. My lord, it has been quoted the relevant para of the qualifications, page 6, my lord. The Constitution has also been annexed, but for easy reference, my lord, we have quoted it here. Paragraph 2, clause 23, Roman 1, qualification. Then 6, must have bachelor or equivalent degree in any discipline. So this is the requirement under the Constitution of the club that, my lord, any candidate has to be a graduate, has to have a my lord, bachelor's degree. Then page 54. Page 54, your lordship will find the election circular. India Club election circular. The election will be held for the following posts for the year 2022-24. The member interested are requested to collect the nomination paper from the members interested so and last date. There are several posts. One is my lord Joint Secretary Sports. He applied for the my lord filed his nomination for Joint Secretary Sports. Then your lordship may kindly come to page 56, my lord. This is important. This is written by the General Secretary, addressed to the plaintiff appellant. Show cause notice for gross misconduct in the club premises. Their member, in reference to the subject mentioned above, I, on behalf of the Executive Committee, invoking Rule 4 of the club constitution, hereby would like to know why disciplinary action should not be initiated against you for the above mentioned conduct of yours on 31st May 2022 around 12 to 12:30 p.m. in the office club, in spite of repeated requests to maintain decorum by yours truly and the club manager. Then, my lord, the plaintiff gives a reply at page 57. May I read it, my lord? With reference to your show cause notice dated 3/6/2022, I am to inform you that I had submitted my nomination papers for the post of Joint Secretary of Sports for the ensuing club election. I received a phone call from the club office requesting me to produce the original copy of my BCom mark sheet. Accordingly, I came and handed the said document as asked for. The learned returning officer examined and compared the same with the Xerox copy and submitted by me with my nomination paper. On my query, the learned returning officer informed me it was okay. The learned returning officer, however, told me that he is under tremendous pressure with regard to the nomination papers submitted by me and he had decided to call for an RTI. This is contradictory, my lord. If it was okay, then my lord, the question of RTI would not have come. At that moment, I was hurt mentally and lost my temper and requested the learned returning officer to allow me to withdraw my nomination paper, which was allowed. I hereby tender my sincere apology for the uncalled behavior and would not repeat such uncalled behavior by me in near future, and I hereby request you for putting an end to this matter. So he apologized also for his misbehavior. Then, my lord, some actions were taken for suspending him for 6 months. That may not be very relevant for the purpose of the injunction, because, my lord, initially he was suspended for 6 months. Then it was on his appeal, it was reduced to 2 months suspension from the membership. And on review filed by him, it was reduced to 1 month. That is kind of long over. Now, your lordship may kindly come to page 62. This is a letter by the returning officer addressed to the, my lord, General Secretary of the club. Submission of forged mark sheet by Mr. Binod Das, the, my lord, plaintiff appellant, for Executive Committee Election of India Club 2022. Dear sir, with reference to the above, I beg to bring to your notice how one Mr. Binod Das, a member of India Club, had submitted a forged BCom mark sheet for the year 1994 Part 1 and 1996 Part 2 in order to contesting the club election held in June 2022. My doubts were proved to be true when on writing to the Deputy Controller of Examinations, Guwahati University on 2/8/2022 regarding the authenticity of the document, the said official verified the credentials of Mr. Binod Das and replied to the effect that the said mark sheets were forged documents. The Deputy Controller of Examination is attached the herewith for your kind perusal. This act of Mr. Das is punishable with imprisonment of jail for 2 years or more under section 465 IPC. But then, my lord, the club authorities did not file any FIR, my lord. Again, on 18/6/2022, Mr. Rajiv Datta, a member of the club, submitted a letter purportedly to prove the genuineness of the mark sheet in the official stationery of the Guwahati University and attested by a notary by the name of Shah Syed Samdur Rahman, registered number so-and-so, copy attached. Again, Deputy Controller informed me that this document had been forged. This has made me infer that Rajiv Datta and Samdur Rahman are also part of the entire conspiracy and liable to be prosecuted under section 465 IPC. Such dubious activities by a coterie of members of the India Club is unprecedented, and it is my moral responsibility as a senior member and returning officer to see that such insidious acts do not occur again. My humble submission to you, sir, is to call for an extraordinary general meeting and let the House decide on the punishment to be meted out to the culprits as per prevailing law of the land. So, my lord, this is the my lord, basis on which it was decided that a meeting should be the matter should be discussed in an extraordinary general meeting. And, my lord, at that stage, my lord, the suit was filed. Now, Deputy, my lord, the Controller of Examinations letter is also, my lord, at page 63. So, my lord, this is the fact, my lords. He wants that, my lord, the authorities in the, my lord, India Club should not discuss his, my lord, the forged document. And that is the purpose of filing this case. So, all the documents are before your lordship, my lord. Therefore, he is not entitled to any injunction, my lord. The club has not taken any action as yet. Club wanted to discuss it in the extraordinary general meeting. Because of the interim order passed by this honorable court, that discussion could not be taken place. And, my lord, we do not know what will be the ultimate outcome in the, my lord, the meeting of the, my lord, of the India Club. It's not that, my lord, we should not suppose that, my lord, action will be taken. Even if the action is taken, my lord, he can still, my lord, agitate it before the court of law. So this is the sum and substance of the, my lord, subject matter of the plaint as well as the, my lord, injunction application. Now, the question that calls for consideration before your lordship is that, my lord, the club has a constitution, and my lord, there are rules and regulations for the members, the code of conduct, and the my lord constitution also provides several provisions, my lord. And under that, can the my lord club be restrained from this even discussing whether my lord to impose punishment or not? That is the my lord sum and substance. Would your lordship like to my lord restrain that? No, 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 no. He may have filed a forged document, whether that is forged or not, you prove that should not be discussed in meeting. And can that be an order? And your lordship, we have, as I am repeating, my lord, we have filed an elaborate written statement and injunction objection in the injunction application. But prima facie, your lordship will see, my lord, he doesn't have a case to go for a trial, and my lord, what is the my lord three golden principles if your lordship considers? Even here, my lord, he does not have any case. And he says, my lord, that it is submitted that my lord, the court did not exercise its jurisdiction. My lord, the discretionary power of the trial court either to grant an injunction on the first day ex parte, or my lord to issue a notice, that is a discretion depending on the my lord on the understanding of the trial court, my lord. And the trial court found that my lord, the notice has to be issued, other side has to be heard. There is no, in my humble submission, my lord, there is nothing in that my lord order which can be agitated really. And we have already filed their objection. And here also, my lord, he cannot say, my lord, what is the my lord, error of jurisdiction by the trial court in issuing a notice. That is the issue, my lord, in the appeal. But this is an ex parte order, my lord, passed on the same day of filing the appeal. And we have filed this application, and this has not been listed for, my lord, about 2 years. And now the matter of your lordship, my lord, therefore my prayer would be, my lord, your lordship will vacate this interim order, and my lord, let the suit proceed. Only thing is, my lord,
so this 23rd 9 2022 is the order passed by this court granting this status quo.
No coercive action.
No coercive action. It means status quo.
Yes, ma'am. Therefore, the club cannot do anything. Club cannot even discuss the matter, my lord.
Okay. Yes, Mr. Viswas.
Well, I adopt the one of the submission made by the Learned Standing Council that where he said, my lord, he doesn't know what would be the outcome of the meeting held by if it is to be held by the India Club. My lord, the outcome may be, my lord, against me in favor of me, and that's where the apprehension is. My lord, if the outcome is against me, my lord, that's where the suit is filed within apprehension, my lord, there it is a clear violation of Article 10 of the Constitution of India Club. Because it is the General Council who has to take the call, not by of an extraordinary general meeting. First. Second, the thing is that the Learned Trial Court, by order dated 21/9/2022, fixed the matter on 20/10/2022 for service report and written statement. And if I may take your lordship to the minutes of the meeting, at page 48 of my FAO.
No, we are only hearing this order 39 rule 4 petition now.
Yes, my lord. For this extraordinary.
Or you want to dispose of both the matter?
No, article, my lord, this FAO, my lord, includes everything, my lord. It's for the injunction purpose. If your lordship disposes of this FAO also, my lord, it will have the same outcome. But this FAO is against the order not passed by the Learned Trial Court. My lord, if your lordship disposes of this FAO also, my lord, directing any direction to the civil Learned Trial Court, it will have a equal effect.
Yes, Mr. Solve. So we can dispose of this FAO also?
My lord, that was my prayer that your lordship will dispose of the FAO and relegate the parties to the trial court. That was my first prayer, my lord.
No, he has not agreed to that.
Well, I am agreeing to the extent that, my lord, the coercive action, it's not status quo. They may hold a meeting, but so far as coercive action against me is concerned, it may be subject to the outcome of the judgment
does not
judgment
provide
will be
any-
passed by the trial court. Then it will serve purpose for both the sides.
No, no, no. We don't know. We, my lord, we have to discuss the matter. We want to discuss it in the, my lord, the extraordinary general meeting. Thereafter, my lord, all the procedures will be followed. Even if we decide that action has to be taken, my lord, it has to be taken as per the constitution.
Well, they may decide, but so far as coercive action is taken, my lord, it may not be taken till disposal
No,
of the suit.
okay, you argue the matter.
Then page 50 in the my appeal, memo of appeal.
Yes.
Regarding the matter of Sri Binod Das, before arriving at a decision, after threadbare discussion, the committee decided to call for an extraordinary general meeting of the General Council to deliberate on the matter and take future course of action, mainly for the following reasons. There were multiple versions of narrations by Sri Binod Das in his letters to the club, as well as to Dr. Ashim Chaudhary, returning officer of club election 2022 to 2024. Later dated 2/8/2022, from the Deputy Controller of Examination, Guwahati University, to Dr. Ashim Chaudhary, states that the credentials of Sri Binod Das bearing code number so-and-so become part 1 examination code number so-and-so do not tally with the official records of the university. Letter from the Controller of Examination, Guwahati University, dated 9/8/2022, to Dr. Ashim Chaudhary, nullifies his letter dated so-and-so to Rajiv Doctor. This nullified letter was enclosed by Sri Binod Das as proof of his credentials, along with this letter dated 17/6/2022 to the club. These are the reasons why the extraordinary general meeting was called for. Now, if I may take your lordship to page 65, Article 10 of the Constitution of India Club.
Yes.
It pertains to disciplinary matters. The club committee shall take cognizance of any infraction of the constitution, any bylaws of the club, violation of the code of conduct, and ask the member to make the preparation in the manner they consider fit in case of failure to comply, or should any circumstances occur or likely to occur to interrupt the harmony, affect the character, or endanger the stability of the club. It shall be the duty of the committee to call upon any member to resign. If he or she declines to do so, they shall hold an in-house inquiry wherein the member shall be given an opportunity to give explanation, if any. If the explanation is accepted, the matter shall stand closed. In case the member is found guilty, the club committee may impose any penalty except expulsion. In case it proposes to expel the member, a meeting of the General Council shall be called to decide the matter. During the interim period, the club committee may, in its discretion, suspend the offending member till the resolution of the matter by the General Council. The matter of expulsion of a member may be decided by ballot or otherwise by the General Council only if it is supported by 2/3 of the members present in the meeting. So, for any infraction of law, for any violation of the rules and regulation of the club, particular procedure is prescribed. But what the Constitution says, there should be a club committee who will decide, who will hold an in-house inquiry. It is not by of an extraordinary general meeting that they will resolve. They will take a decision that I should be expelled from the club. But if this decision is taken by the club, the entire purpose of filing the suit will become infructuous. But my apprehension is limited to that aspect only. Regarding holding a meeting by the India Club, whether they take a decision or not, the decision, if it comes against me, but there my balance of convenience lies, and the irreparable loss and injuries lies. But the prima facie, I've been able to show before this honorable court that there is a prima facie case to go for trial. In view of
Mr. Biswas, you see, this petition is filed under Rule 4. So the order which is sought to be varied or sought to be vacated.
Was the
Is
order?
there any discussion about prima facie case, balance of convenience, and irreparable loss? Now, this court cannot add the prima facie case and this balance of convenience to that order now.
But they have come with a petition under order 39 rule 4 with an allegation that that order is order 39 rule 4 says if there is any ex parte order passed against them. But this is no longer an ex parte order in my humble submission. The first day the order was passed, saying
How
that
can you say that this is not an ex parte order, my lord?
if I may
When all the
complete.
matter is heard, my lord.
This first day the order matter was disposed of, my lord. I would say due to some error. We myself filed a review petition.
No, Mr. Biswas, going by the order dated 23rd 9 2022, can it be said that it is a bi-party order?
That's why, my lord, we myself filed a review petition to correct this order. And when the review petition
No. You are not following my point. Can it be said that this is a bi-party order?
It was an ex parte order.
Then why you are saying that it was passed in presence of both the parties?
My lord, in the later part, when we filed a review petition, the learned court, my lord, reviewed the matter to the extent of, my lord, disposal. There the parties from both the sides were present. The respondent was present. In their presence, the order was passed, my lord. They did not agitate that the order should not be passed. And so far as ex parte order is concerned, my lord, there is a provision, my lord, ad interim injunction may be granted.
No, in the review petition, is there any scope for them to?
For a review petition, we filed for the simple reason, my lord, the first day the case was disposed of, matter was disposed of. We said in the review petition the matter should not have been disposed of, a notice should have been issued to the opposite party to give them a chance. We fairly submitted before the court that first day the order matter was disposed of, which was not correct.
The order was perhaps passed in the open court?
Open court.
In your presence?
In our presence.
Why don't you point it out?
My lord, we point, my lord, it was in a, my lord, we mentioned the matter in the morning hours. As the last item it was taken, my lord. Perhaps it was not in the open court, I forgot, my lord. Perhaps not in the open court or in the chamber, I forget, I don't know. Learned Senior Counsel, Mr. Monto was appearing, I was assisting. So perhaps it was filed, passed in the court, but somehow we missed that point, my lord, while dictation, my lord, to listen to the dictation. But later on, immediately when you found this order, my lord, we filed a review petition.
Okay, anyway, as per this constitution, the extraordinary general meeting has no jurisdiction to deal with the issue.
Yes.
That is your contention.
That is my prima facie case. And balance of convenience in my favor for this simple reason, if I am expelled, my lord, from the club, my lord, it will cause irreparable loss and injuries not only to my reputation, but the entire image of mine will be, my lord, spoiled before the society. That's why the suit is filed for protecting my interest. Let the suit proceed. Whatever outcome comes, my lord, will receive it, will take it. Until then, my lord, if this decision is taken for expelling me in a meeting to be held, my lord, purported to be held by the respondent, my suit will become infructuous, my interest will be harmed, my entire case will go. This is my humble prayer. Out of thousands of members, my lord, if I go there, my lord, I think this will not cause any harm to the India Club, my lord. It's a big club.
Heard Mr. M.K. Sodore, Learned Senior Counsel, assisted by Mr. Learned Counsel for the applicant, and also heard Mr. Biswas, Learned Counsel for the respondent in I number 564 of 2023. Argument concluded, order reserved.
Much obliged.
Highly obliged.
Pending item 41.
On Monday.
Monday, we have many cases, same fate will happen. Mitra?
Lordship, she can argue. Or Lordship, I can make my submissions.
Lordship, their main ground is delay. Regarding delay, Lordship, they might.
You ask your counsel to remain present.
Lordship, on Monday.
Okay, Monday then.
Lordship, can you do Wednesday in that case?
Wednesday.
Lordship. Obliged, Lordship.
Highly obliged.
On the appeal being made by Ms. Deka,
Deka.
learned counsel appearing on behalf of Mr. S.C. Kail, learned standing counsel for the NCB, respondent. The case stands adjourned to be listed on.
Lordship, it can be on Monday. I'll argue on Monday, Lordship. Can be on Monday, Lordship.
Okay, Monday.
41, 42. Okay.
Whatever section, whatever code you go ahead and
Item 26.
Highly obliged.
Let me go, Lordship. Well, this matter has come up because we did not take step as directed by this honorable court. It has to be taken within 2 days of the last order. Lordship, will take it on Monday, my lord.
Steps. Heard, Mr. Your good name?
S. Kakoti.
S. Kakoti, learned counsel for the appellant.
Appellant.
Mr. Kakoti submits that due to some inconvenience, step could not be taken upon the respondents and applies for granting him 2 days time to take step upon the respondents. There is allowed. Step be taken upon the respondents within 2 working days from today. This is a list the matter that by register tools with AD and also by usual process. This is a list the matter after 4 weeks.
4 weeks.
4 weeks.
27.
Right, Your Lordship. We have taken steps in all 3 ways, my lord. And dusty service was served on, my lord.
You have filed the affidavit?
Yes, the affidavit is there. my lord.
When?
Flag A, my lord.
Like A.
Flag A. On 17/11/2000 for 24 minutes. And somebody has appeared because this case was, the post list was published a day before yesterday, my lord. And yesterday somebody has appeared. In the website it was shown, my lord.
Is it reflected in the cause list?
No, post list, because the post list has published, my lord, before their appearance. Some A Banerjee is still showing in the website, my lord.
A Banerjee?
Yes.
Okay, wait for 1 or 2 days.
Yes.
The next week we will take it up. Heard Mr. S. Sahu, learned counsel for the petitioner. Mr. Sahu submits that he has effected service upon the respondent by Dusty Muth, and an affidavit to that effect has also been filed before this court. And further, Mr. Sahu submits that name of some counsel has been reflected in the cause list day before yesterday.
Not cause list, in the website, my lord.
Website.
Yes.
The website. But today none appears. Accordingly, it is provided that the SSL lists the matter on next week.
My lord, actually on 27th, the case is fixed there, my lord. So on 26th or 27th, 27th, 29th probably.
26th or 26th.
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 Item 30.
Obliged.
May I please, Your Lordship? In this case, Your Lordship, I am the respondent claimant number 1, Your Lordship. Insurance company was preferred the appeal. I have filed an IA for release of 50% amount, which has been already deposited before the registry of this High Court, Your Lordship. IA number 2359, Your Lordship.
Okay.
My lord, kindly see the order copy they have already annexed, my lord. Fully stay, my lord, already stay, and there is analogous case already admitted and fixed for hearing, my lord.
At the time of admitting the appeal, Your Lordship, Honorable Court was admitted the appeal only condition that the 50% amount may be deposited before the registry. However, if Your Lordship will find at page 12, Your Lordship. However, the amount shall not be allowed to be released without leave of this court, Your Lordship. There is not fully stay, Your Lordship.
Matter may be fixed for hearing, my lord.
And
so this IA is for releasing the 50%
yes,
amount.
Lordship, which has been already deposited.
So you have objection here?
Yes, my lord.
Why?
They have only act policy, my lord.
Because your lordship,
The insurance is not liable to pay, my lord.
insurance company has not denied the fact of the case, your lordship. Their grievance only that, your lordship, the driver of the offending vehicle has
You
not
kindly
possessed
see
the
the order, my lord.
full-fledged
Last
driving
order.
license, they're the learner. So, on this aspect, learned court also consider liberty also given to recover the from the driver also, your lordship. So,
It is remain state in the
I have
disposal of
stated,
the
your lordship,
my
at
lord.
page 7,
Last
your
order,
lordship.
my lord.
So liberty is given to recover the amount from the driver.
Driver, your lordship.
Let's see the order.
At page 10 onwards, your
Order
lordship.
dated 7/6/2023, my lord.
Which
In
order?
the IA or in the appeal?
In IA, my lord.
Also.
Okay.
Which order, your lordship? Learned court below.
Page number?
Lordship, which order?
IA?
IA, my lord,
IA
7/6/2023, my lord. They have annexed, my lord.
At page 10, your lordship, onwards. Middle portion, your lordship. At page 12.
Order of the,
MEC.
yes.
Yes, lordship. We have filed an chorus objection, your lordship, number 8 of the 2024, your lordship. If your lordship will find at page 33, your lordship. At page 33, your lordship.
33
Of chorus objection, number is 8, your lordship. Page 33.
No, you show me the order passed with the learned tribunal.
Yes, lordship.
Where?
We have annex in our chorus objection, your lordship. By chorus objection number 8 of 2024, your lordship.
There is no court objection in the list.
Where it is mentioned that insurance company may recover the amount from the driver?
Yes, lordship. At page 33, your lordship, paragraph number 15, your lordship, down below.
No, in the order
Yes, lordship.
of the tribunal.
Yes, lordship.
In this page.
Page number 33.
Internal page number of the judgment.
Or internal page number 25, your lordship, of the judgment.
25?
Yes.
No, black is yes in heaven.
Into court objection because of the list one.
You are appearing in item number 30.
30, yes.
The order of the tribunal
Yes, lordship. We have
comprises of only 10 pages.
Yes, my lord. Yes, my lord.
You are not sure in which case you are appearing.
Lordship 30, lordship 2620 of 2018.
My lord, I
You
think,
come to the
there-
judgment.
There
Yes,
were two
just-
analogous case, my lord, I think.
We are taking up this item number 30 now.
Yes, lordship, 30.
2620.
10.
There is different judgment. Lordship, can I forward this?
Which one?
My first objection petition. There also
We are not
available
not
in
concerned with the cross subjection.
item cross objection number 8.
Let the matter may be heard, my lord, at the time of the.
MSC appeal number,
LCR is a-
MSC
received, my
appeal
lord.
number 224, 2023.
LCR received, my lord.
227.
What is the name of the party?
Nirmal Chandra Mitra, your lordship.
No.
I have the documents.
United India Insurance Company versus Nasimuddin.
Nijamuddin, yes, my lord.
Sorry, your lordship, I didn't define file. I'm so sorry, your lordship.
We will impose cost upon you.
Sorry, your lordship.
What, sorry, you are spoiling time of the court.
Sorry, lordship, can we fix in another day, your lordship? Because
LCR received, my lord, let the matter may be
Maybe next year.
heard, my lord, altogether, my lord.
matter may be next for hearing.
No, madam, you have submitted that there is an order for not releasing the amount except the permanent leave of the court, where it is mentioned. Yes, madam,
Yes, my lord.
I am asking you.
Yes, my lord. My lord, they have annexed, my lord.
No, you have
not to
submitted that
release my-
there is an order of this court not to release the amount
My lord,
except the leave of
even
the court.
stay, my lord, till the disposal of the appeal, my lord.
Pardon?
My lord, last order, my lord, 6/2023, my lord. There is, all the amount may be, stay, my lord, remain stay till the disposal of the appeal, my lord.
Yes. Where it is stated that amount should not be released till without leave of the court. Few minutes back, you have submitted before this
Yes, my lord.
court.
Yes, my lord.
On what basis you have submitted it?
There is a stay, that's why, my lord, and there is act policy, my lord. There is no liability of insurance, my lord.
That's all right, but where is the order that you have submitted that amount should not be released except leave of this court? Where it is stated?
No, my lord, there is.
Then why you have submitted? As agreed by learned advocates of both the parties, recusal is the matter in the first week of December.
So grateful. 31.
My lord, service is complete. There is a delay of only 21 days, my lord. They have no objection, my lord. So delay may be
Yes,
pardoned,
any
my lord.
objection?
No, Lord, I have no objection.
Heard learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred for condonation of delay of 21 days in preparing appeal against the judgment and award dated 28/3/2024 passed by the learned member MSCT Bozali Pachala in MSC case number 98 of 2019. Why the appeal could not be filed in time?
My lord, certified copy obtained, my lord, not on time, my lord, after, it is, explained in para 3, 4, 5, and 6, my lord, the learned tribunal delivered judgment on 2023, 2024, my lord. And we have obtained the copy 30, 2024, my lord. Thereafter,
Why you could not obtain the certified copy in time?
Many in lower court, my lord, they have obtained and forward the copy to legal opinion for the advocate in Bogaigaon, my lord. Thereafter, they send copy to the regional office, my lord. That's why, my lord, only 20 days, 21 days is delay, my lord.
Is it the ground for condonation of delay?
Thereafter, my lord, in para 6, my lord. Advocate could not collect the file because my lord engaged advocate was out of station due to summer vacation of the Honorable High Guwahati High Court, my lord. On 1/7/2024.
There was vacation court?
Yes, my lord.
Why you could
1/7
not file it in the vacation court?
My lord, we have engaged, they have engaged engaged council is out of station. That's why, my lord. We could not file on time, my lord.
The learned counsel for the applicant submits that certified copy of the judgment and award passed by the learned member MSCT Bozali Pachala could not be obtained in time. And thereafter, the judgment and award was sent to the regional office, Bongaigaon.
Regional office at.
Why you have
Guwahati,
sent
my
it to
lord.
Bongaigaon?
My lord, always branch office sent to the regional office, my lord. Thereafter, they
Sent to the branch office at Bongaigaon, and thereafter it was sent to the regional office at Guwahati for opinion. And in the process, some delay is occurred, and the same is not intentional. And therefore it is contended to, no, and the same is explained. Paragraph number 4, 5, and 6. And therefore it is contended to allow the application. On the other hand, Mr.
Yes, I can.
S.A.
Yes, I can.
Learned counsel for the respondent submits that he has no objection in the event of conducting delay of 21 days in filing the appeal. Connected appeal. Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents plus on record, and also the statement and averment made in the paragraph number 4, 5, and 6. And it appears that the delay of 21 days is sufficiently explained, and therefore this court is inclined to condone the same. In terms of above this, I stands disposal. In view of order passing the IA, now the registry will proceed to register the appeal and list the same before the court.
32 and 33.
My lord, item 32, writ petition was filed challenging the appointment order of the private respondent.
So this IA,
When the case was pending for determining seniority between myself and the private respondent, who is senior among us, then I have been transferred to another school, and therefore I approach this honorable court by filing IA number 3515. And your lordship was pleased to stay the interim order, stay the transfer order till today, because the main case is fixed today for obtaining instruction. When
They have not filed any affidavit government.
they were supposed to produce the instruction, who is senior among us?
Lordship, I have not received any written instruction, but verbal instruction, they let me know. As per instruction, Lordship, if the date is same for joining, then their age is counted for seniority.
who is senior now?
As per
Respondent, private respondent number 5 is senior, madam.
Senior.
Petitioner is
Here my question is that earlier he was transferred to another school
on public interest.
on public interest to join as an in-charge headmaster. But that the teacher of that school has filed another case. That's why he has been sent here. So that has been stayed. So that matter is still sub judice. In the meantime, again, when I was appointed as the in-charge headmaster of this same school, he has come before your lordship. Earlier suit is still pending. And my lord.
Maybe there are two different cause of action.
Yes, that's true. But question is here that we have filed in 2 affidavits. He has become on his own request, he has transferred at one time. So once he leaves this school on his own request, he loses his own seniority. That also, I think, has not come in the record.
No. He was transferred on his request to another school.
Not
No,
on
no.
public interest.
Public interest. Once
No,
his
second
own
time.
interest, he has been transferred. Once
This second time also, when he has challenged it, my lord, that I am the senior, there is a vacancy in another school, he has been given accommodation to that school. So you go there and join as in charge headmaster. So that also again he has challenged here. That because earlier case is still pending, how you have done it now?
Otherwise, Lordship, the DO have no authority to transfer. Only the appointing authority have the right to transfer inter-districts.
Who had transferred him?
The
DO, my lord, I
DO.
see DO has transferred.
Here, Lordship, the DO make the transfer, but the authority is Director of Elementary Education, Lordship.
Appointed.
Because the director is the appointing authority.
But the moot question is that, my lord, he wants the headmaster.
No, this order is illegal
Yes,
without
Lordship.
any jurisdiction.
Yes, Lordship.
Then earlier case is also illegal. That was done by
No,
ADC.
no, we have Mr.
Now,
Biswas.
ADC is the authority.
No, Mr. Biswas, we are not concerned with the
Yeah,
earlier case.
that has come today before your lordship. Next, another
There is
item.
no approval of district level committee. District level committee's approval is also required, Lordship, for making any transfer. And after that, the Director of Elementary Education approved that order. But here the order is passed only by the DO.
Without approval of the director.
Without approval.
There is
And
no
also
approval
the
from the district level committee or the director.
Well, our affidavit, IA has not come, my lord. Let it come. We have filed on IA, my lord. Today morning, I could not take permission from your lordship. I was a little late, that's why. That IA has not come in the record.
IA is for?
Affidavit opposition we have filed one.
Who is senior among us in the main writ petition? When the writ petition is pending, your lordship is deciding who is senior. When the court is in session, I have been transferred. And therefore, your lordship protected me till today.
But
who is senior? The standing council has submitted that my date of joining and his date of joining is on the same date. My date of birth is 4 years senior. I am in the year 1968 and he is 1972.
That is true. But question is
That is true.
He wants headmastership. The authority has given him headmastership. Once earlier, that is been stayed. Now, second time, how he has again approached, court has, the department has again considered, yes, there is a vacancy, you go there. He has again challenged.
No.
No, that
Let
order.
the authority should put into writing affidavit, my lord, in the form of affidavit.
I will bring all these in record, Lordship, within 2 weeks, Lordship.
Within 2 weeks.
2 weeks, Lordship.
An interim order may be formed.
Yes.
Heard Mr. N. Sharma, learned counsel for the applicant, and Madam S. Kumar, learned counsel for the respondent, opposite party number.
1, 2, 3, and
4.
4, Lordship.
1, 2, 3, 4, and Mr. Biswas, learned counsel for the respondent number 5.
Yes.
Mr. Biswas submits that he had filed one
IA,
and the same is not listed before this court.
affidavit objection, affidavit I have filed. Not IA, affidavit, sorry.
Affidavit in opposition. In which matter, this IA or in WPC?
In both petition I have filed, both IA and this one.
In both the petition?
One objection has been tagged in the writ petition. Okay. No, we should.
This matter has to be subject to what your lordship said. Not some matter has to be hard finally. Government has to file affidavit. Lordship may fix a date.
Yes, he has prayed for time.
They fix for time, 2 weeks. That, because the matter has to be hard finally. He was senior to me. He has been promoted in another case. He has
That
been,
has also come to the today.
it has been stayed there at their own instance. So it has to be decided finally.
Okay. And say the affidavit in opposition is not placed on record, and accordingly it is provided that recusal is the matter when?
2 weeks.
After 2 weeks. After 2 weeks.
That may be reached.
Probably suggested that.
on 13th December.
In the meantime, Ms. Kuar, learned standing counsel for the respondent number so and so, shall file her affidavit in opposition. Place the matter on.
13th December. No, not
Well,
13th.
interim order
After 16, my lord, anything.
After 16.
After 16th December. In the month of January.
Yes.
In the month of January.
Till then, interim order passed earlier in I number so and so shall continue.
Another matter also has come. Your lordship, there is order from the court too.
32, 33 tables.
That is also where he has challenged, when he was given headmaster too. There also authority has not filed any affidavit.
Okay. Here you are for the petitioner.
No, my lord.
In WBC number 2285.
Is the petition.
I am the petition.
Oh, heard Mr. S.A. Biswas, learned counsel for the petitioner. And you are here?
Yes, my lord. My private
And
testimony.
Mr. Sharma, learned counsel for respondent number
7.
7. And Madam Koa for respondent number 1, 2, 4, and 5.
Oh, yes, Lordship, 1, 2, 4, 5.
3.
3 is Deputy Commissioner, District Commissioner, Lordship.
What's that? Done appears for the respondent number 3. Ms. Kaur submits that she will file affidavit in opposition. When? Within 2 weeks? Within 2 weeks. They are allowed to resocialize the matter after 2 weeks.
And the name of the senior counsel, BT Das may be reflected. It is not reflected here. It is
Mr. Biswas submits that he will be led by Mr. B.D. Das, learned senior counsel, but his name is not reflected in the cause list. Accordingly, it is provided that rest shall do the needful in this regard.
34.
Well, both the cases will come together.
Date may be fixed, my lord.
Date may be
Otherwise,
fixed.
no. Date-
Both the cases may come
Last week
together.
of December,
After 16,
after 16 years.
and in the first week of January, on the 6th January. Item 34.
Please do, Lord, you to be on those of delay petition, first time lordship, to notice my kindly.
Okay. Notice. Pardon? 136 days.
35.
35 is also same lordship, for no delay petition, 35 and 37 lordship.
36 and 37.
No, 35 and 37.
35 and 37. Okay.
36.
Wait, please, your lordship. Lordship, this I is for condemnation of delay and there is a delay of 35 days.
Okay, let notice go.
So, much okay.
35 days.
Item 46.
Peru ka order dated 5/8, madam. The respondent number 1 already date, madam, but my line of code has not provided the information regarding madam address and date of death.
Your lordship, with all due respect, your lordship, actually, I have communicated with my clients, your lordship, and they have provided the half information today itself only. So I have provided the same, your lordship, the remaining information which is seeking by my learned friend, I will provide by next week, your lordship.
When?
By Monday, probably I will collect the information,
Okay.
your lordship.
As agreed by learned advocates of both the parties, rest shall raise the matter on
Friday, 29th.
Friday.
Hello.
Friday.
Oblige.
I know, your lordship.
47.
Happy the lordship.
Yes.
My lord, in this matter, my lord, as per the office note, my lord, I have checked it, my lord. Respondents, my lord, 1 to 4 and 2A, 2B is their file Kalatama. And so far as 5 and 2, 18, their performer respondent consent service yet to be completed. And this honorable court call for LCR, but trial court record received, but appeal court record yet to be received, my lord.
Okay. Heard Mr. Decker, learned counsel for the appellant, and Madam.
I'm appearing for respondent number 1, 2A, 2B, 2E, 2D, 3 and 4.
3 and
Am
4.
I-
Office note dated 19/11/2024 indicates that service report upon respondent number 5 to 18 are still awaited. Awaited?
Awaited.
Office note also indicates that LCR of TS number 15 of 2017 has been received, but the LCR of TA number 59 of 2022 has not been received. Rest is a useful reminder to the learned First Appellate Court for transmitting the record of title appeal number 59 of 2022 without delay. List the matter after 2 weeks, awaiting service report upon respondent number 5 to 18.
Yes. Keep the operation.
48.
Meet the Lordship. Lordship, this matter is ready regarding service and records.
Lordship, this matter has come up for orders. We have listed the matter for praying for withdrawal of the deposition of 25% of the compensation award.
You have filed IA?
No. Means in the same case, in the main case, an order shall be passed by your lordship so that we may be allowed to withdraw the 25% of the deposited amount. That is already being deposited before the registry.
Have you filed any IA?
Lordship,
Then
They have to file an IM motion.
you file an IA? Your good name, please?
And Saikya Lordship.
Heard Miss N. Saikya, learned counsel for the appellant. Then Madam
A Bora.
A. Bora, learned counsel for the respondent number
Respond number 5-6.
5 and 6. None attached for the respondent number 120. Office note dated 5.
Lordship, in this case, 5 and 6 are the owner and driver. So they cannot withdraw the amount, Lordship. Claimants have to withdraw the amount.
Oh, sorry, I'm for 5 and 6.
Owner and driver cannot withdraw the amount.
I'm really sorry for that because I have not received the memo till date, Lordship.
There is no up to date office note there. 29/7.
July.
8/3. Office note dated 29/7/2024 indicates that LCR has been received. Office note also indicates that notice upon respondent number have been duly served. But respondent number 4 remain unrepresented today. List the matter after after 2 weeks. Okay. That respondent number. Respondent 1, 2, 3. এইকেইটা হেৰি হ'ব চাৰ্ভিছে কমপ্লিট হ'ল ইয়াতে অফিচ নাই এইটোৱে চাৰ্ভিচ reports of notice have been issued. Notices linked to corresponding have been issued. 9 May issued. Order notices have been issued by ordinary posters. Registered ordinary vote. May 2011. Serviceable report. Hearing hearing to no, it was good. Good. It will have to service code for them. Though it is reflected in the order dated 31/7/2024 that none appears for the respondent number 1, 2, and 3, and the case is ordered to be listed for hearing in due course. Yet, the office notes are silent. Office note dated 8/5/2024 and subsequent office note dated 29/7/2024 are silent regarding service of notice upon respondent number 1, 2, and 3. Accordingly, it is provided that the learned counsel for the appellant shall take fresh step upon respondent number 1, 2, and 3 within a period of 2 working days from today by registered post and also by usual process.
Actually, 2 and 3 are minors.
Yes, yes. Over here, appears. No, silent now. They are minor.
Yes, Lord.
Who had received notice on their behalf then?
We have not sent notices upon respondent number 2 and 3. We have sent notice on respondent number 1 only. Not. One is the mother of respondent number 2 and 3.
Later on, it appears from the record that some counsel entered appearance on behalf of respondent number 1. And as such, no notice is required to be issued to the respondent number 1, 2, and 3.
49.
In this matter, Lordship was pleased to stay the execution proceedings and notice was issued. The other side has appeared, except number 2 and 4 has not appeared.
My instruction is that 2 and 4 have already expired. So an office will also reflect that it has expired and addressing not found available there regarding respondent number 4 also. I am appearing for 1, 3, 5, 6, 7, and 8.
Heard Mr. S. Ahmed, learned counsel for the petitioner, and Mr. R. Fokon, learned counsel for the respondent number 1, 3, 5, 6, 7, and 8. Office note dated 21/11/2024 indicates that respondent number 2 expired and respondent number 4 and service upon respondent number 4 could not be effected due to insufficient address. The learned counsel for the petitioner is directed to take step upon respondent number 4.
Actually, my instruction is that 4 has also expired. Even they are family occupied, they could take the instruction later.
You obtain instruction, it is your duty. The learned counsel for the respondent number 1, 3, 5, 6 to 8 also submits that respondent number 4 also suffered demise as per his information. Accordingly, it is provided that the learned counsel for the petitioner shall take necessary step for impleading the legal representative of the respondent number 2 and 4. This is the matter after 2 weeks.
Yes, sir.
Lordship, interim is.
Interim order passed earlier shall continue.
Your Lordship, scan copy of the LC has not received yet, Lordship. Can I remember?
Scan copy was called for.
Lordship, call for Lordship.
Recessal issue reminder to the learned trial court for transmitting the scan copy of the record without further delay.
Item 50. Item 50.
None appears for the petitioner on call. Recessal is the matter after 2 weeks.
51.
Please, Lordship. Lordship, this is filing for withdrawal of the amount, Lordship, which has been deposited by the 50% amount, which has been deposited by the insurance company.
Lordship, we have filed an objection.
Why?
Because in this case, Lordship, the driving license of the driver was not valid at the time of accident, Lordship.
Whether you have taken such a plea before the tribunal?
Lordship, DW1 has stated in her examination in chief, Lordship.
Whether any issue was framed before the tribunal, by the tribunal?
As per order, tribunal order, Lordship, they have not, insurance company have not examined any person from the concerned authority whether to prove the authenticity of the driving license, whether it is genuine or not, Lordship. Therefore,
Lordship, the driver at the time of the accident, he was holding a driving license, but the driving license, he was authorized to drive only motorcycle with gear and three-wheeler, non-transport. But he was not authorized to drive a transport vehicle, Lordship. There was no specific endorsement, Lordship, at the time of accident.
Have you seen the recent judgment of Supreme Court on this point?
Lordship,
He was holding a LMV, light motor vehicle, this license.
yes, Lordship.
yes, Lordship.
So he can drive the vehicle, transport vehicle also.
Yes.
In such cases, Lordship, pay and recovery is given, but
We will see later on. Heard, Mr.
And Lordship.
And
Lordship.
learned counsel for the applicant. And also heard Madam N. Saikia, learned counsel for the respondent. This interlocutory application is referred by the applicant for allowing for allowing them by the applicants for allowing them to withdraw the 50% of the awarded amount deposited before this court pursuant to order of this court dated when the order was passed.
Yes, Lordship. Order for Lordship, to deposit the amount to 2024, Lordship.
To
IN number 242/2024.
24 to 224. Where is the petition? Then also there is the objection filed by the respondent.
Page number 9, Lordship. From page number 9. In I.
The learned counsel for the respondent submits that. Respondent or you for appellant?
Yes, Lordship.
Appellant submits that at the relevant time, though the driver was holding driving license, he was not authorized to drive the transport vehicle. And there was no endorsement in the driving license to that effect. And therefore, he has opposed releasing the 50% amount before this court. Deposited before this court. But, having taken note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, and also keeping in mind the legislative intent in enacting the benevolent provision of law, benevolent legislation, this court is inclined to allow this petition. The applicants are allowed to withdraw the 50% of the amount from the registry of this court. Awarded amount was 5 lakhs. 5 lakhs. 5 lakhs. In terms of about this ISS closed. Hello.
Make these are also. I have a mention to make that in regard to item number 44 of a supplementary list, that during the time of reaching the meter, my senior was late on some other phone. Kindly fix the meter on Monday.
Monday not possible. You take a date from him.
Lordship, maybe Tuesday or Wednesday.